Okay, I'm going to get started. This is Kim Hildred. I've just turned off my video because I'm having some internet issues, so I hope everyone can hear me. So good afternoon, and thank you for attending this important discussion on dedicated accounts for children receiving SSI. So anyway, the roundtable continues the board's work on dedicated accounts, which we first examined in depth in our 2019 SSI statement included in the Social Security's annual report to the President and the Congress on the SSI program. While the board did not make a recommendation related to dedicated accounts at that time, we committed to continuing our research into this issue, and that's why we're here today. So today we are so pleased to be joined by a group of several experts on dedicated accounts who will discuss the purpose, oversight, administration, challenges, and range of policy options regarding dedicated accounts. And our discussion today will inform the board as we decide on our next steps in this important policy area. So before we begin the discussion, I want to welcome my fellow moderator, Nancy Altman from the board, who will be moderating this afternoon's session, but I know we'll play an active role, the second session, but we'll play an active role in this one, I'm sure. And I'd like to introduce our speakers and panel members. They're joined by Joanne Barnhart, former Commissioner of Social Security, Gregory Brusick, who's the Vice President of the National Council of Social Security Management Associations. He is the District Manager of Bellingham, Washington Field Office at Social Security. Termat T. Doucette is the Project Director for the Children's Disability Project, Greater Boston Legal Services. Rachel Emmons is the Washington representative for the National Council of Social Security Management Associations. Danielle Flint is a parent representative payee of a child with a dedicated account. James Klein, San Francisco Audit Division Director of the Office of the Inspector General with Social Security. Linda Landry is a senior attorney with the Disability Law Center, Massachusetts Protection and Advocacy. David Lescarini is president of the district manager of McMinnville, Tennessee, field office at Social Security. And Mary O'Connell, professor emerita, Northeastern University School of Law, retired. So again, we are so thankful for all of your time and participation in this important discussion. And I wanted to just cover a few housekeeping items before we begin. The roundtable is being recorded with live closed captioning. And to turn on your captioning, please select the CC icon in the bottom right-hand corner of your Zoom menu and choose Show Subtitle. The agenda and participant bios can be found on our website. The recording of the event and complete supplementary materials will be posted on our website following the roundtable. Attendees are muted. Time permitting, questions from the audience will be addressed during or at the end of the day. If you have any questions, please submit them via the on Zoom or email them to events@ssab.gov. And if you have technical difficulties, please email events@ssab.gov and a staff member will help you resolve them. So we're going to this first part of the discussion is the legislative purpose and oversight of dedicated accounts. So to kick us off, Professor Mary E. O'Connell from Northeastern University School of Law will present on the legislative history of dedicated accounts and their challenges as outlined in her law review article. So Mary, take it away.
Thank you very much. Thank you for having me. When you write about something as small and narrow as this, you don't get invited to a lot of parties. So I'm actually delighted to have a chance to speak to people who are as interested in this piece of the law as I am. What I'm going to do is ask you to buckle your seatbelts and come with me from a trip that's going to start in 1972 and end in 1996. 1996 is the year that Congress created the mandatory dedicated account. 1972 is the year that Congress added SSI, the Supplemental Security Income Program, to the programs that are available to Americans. So in doing this work, and the full article is 76 pages long with 600 footnotes. So I spent a long time on this, but I think what I saw were a number of different threads coming in at different points in the time span that I'm going to be talking about, all of which affected Congress's perception of children with disabilities, and all of which affected Congress's perception that the dedicated account would be a positive addition to SSI. So I'm going to take us back to 1972 and to President Richard Nixon, who is actually working on, my house is really close to the street, and when anybody backs up, I get to hear the backup signal, but I think it's turned off now. So Nixon and Daniel Patrick Moynihan, unlikely friends, were very enthused about the possibility of expanding benefits for Americans. In particular, this 1972 statute, which created the Supplemental Security Income, the SSI system, also created the COLA for people who are retired or survivors of retirees. The COLA is the cost of living adjustment. So if you're old like me and you are actually collecting Social Security retirement benefits, you get a little notice at the end of every year telling you that your benefits have been adjusted, pretty much usually upward, to match the cost of living. This was important because Congress really didn't want to have to fight about adjusting Social Security retirement benefits every year. So the COLA was enacted in the same bill that created SSI. And in addition to the COLA, there was a sudden bump up in benefits for retirees and survivors by 20%. And I have the feeling that was backfilling for the years that the COLA hadn't been in effect. There was also a real interest by the Congress in people with disabilities and people who were elderly. And in both cases, this was SSI, and it was limited to people who have very limited resources and very low incomes. Now, there are some exceptions on the resources. You can't own a house, you can't own a car, but if you have money in the bank, you're not going to wind up on SSI. So this program for people with very limited assets and very limited incomes was also going to be only for elderly people or for people with disabilities. At the same time that Congress had all of those things out in front of it, there was a great deal of interest in something that's called the FAP, the Family Assistance Program, and it never got enacted. If it had, it would have provided a federal benefit every month to every family in the United States that included a child under 18. That might sound strange to us today, but in fact, a lot of European countries have a program like that. So here we are with all of these things out on the table. There was real discussion about the FAP. I think it was probably the most controversial piece. But as that's getting discussed, and as the supplemental security income, the SSI benefits are being discussed, an idea emerges that maybe SSI ought to apply not just to adults, but to children, obviously not the old age program, but to children who had a disability. That was controversial. I'm going to bring it up again later in a slightly different context. But the ultimate resolution was by the chairs of the two powerful congressional committees, Wilbur Mills on Ways and Means and Russell Long on Senate Finance, that they would go with adding children to the disability category, but they would not approve the FAP. And that's what emerged from these discussions, and that was what was signed into law by Richard Nixon in 1972. Almost immediately, there were some big surprises. When Congress was getting information on starting a disability program and an old age program for people with very limited incomes and assets, they were told that about 2/3 of the people on those rolls would be elderly and 1/3 would have disabilities. And at the very beginning, that turned out to be true. The program was enacted in 1972. It took until 1974 to begin the rollout, which was a mess, but that's a different story. By 1978, 2/3 of the people on the rolls were people with disabilities and 1/3 were elderly. And 4/5 of the applications in 1978 were by people with disabilities. So what Congress thought of as a program to help those people who got into late life and have very limited assets and income, but also to help people with disabilities, really became a disabilities program. The reason this is significant is that disability programs are much more expensive to administer. And it is very likely that a person with a disability will stay on the rolls longer than a person who doesn't go on the rolls until she's at least 65 years old. So Congress had given birth to a much more expensive and complicated program than it had any reason to believe. Probably part of what people hadn't focused on was the deinstitutionalization of people with mental disabilities that actually began in the 1950s. In 1955, there were 500,000 people living in institutions for the mentally disabled. They spent their lives there. By 1994, there were only 72,000 people in such institutions. There had been a massive, massive change, much better use of medications, and just a sea change in society where people with mental disabilities tended to stay with their families and stay in their homes. Of course, when they lived in the institutions, although there were lots of horror stories told about the institutions, the states which ran them paid for their keep. Now that they were back with their families or back in society in some way, some money was going to have to come to support these people. And I don't think from all of the research that I've done that Congress had any real understanding that that's what they were facing when they created this statute in 1972. So let's go on to the period after. We're going to move through Richard Nixon. We don't even have to think about Gerald Ford. But by the time we get towards the end of the Carter administration, the SSI rolls have grown dramatically. And there's a lot of concern about how costly SSI has become. And so towards the end of his term in office, President Carter signed a statute which created the Continuing Disability Review, the CDR. And all it said was, after 3 years, you should have to, you, a person collecting SSI because you're disabled, you should have to do something to show that your disability is continuing. And that's all. Well, Carter leaves office, Ronald Reagan takes office, and I'm not, blaming Reagan, but there's really a change in how Americans are seeing the role of government. I mean, Reagan famously said, "Don't ask the government to solve your problems, the government is the problem." You don't have to believe that, but you can see why a sudden escalation or a continuing escalation in the SSI rolls, which are very expensive, would be a cause for concern. What the Reagan administration decided to do with these seemingly innocuous CDRs is really ramp them up, do many, many more of them, and try to cherry pick the cases where people might have recovered from their disability. So to throw some numbers at you, and I do love numbers, but I think all of this information is available from the people at the advisory board. In 1975 and 76, about 22% of people who went through a CDR had their benefits terminated. The rest continued. By 1978 to 1985, it was 46. It was twice as many people were being cut from the rolls. In those days, if you were cut from the rolls because of a CDR, you lost your benefits immediately. You had a right to appeal, but during the appeals process, you would not be getting any money. Obviously, if this is the money you're using to survive, you're in big trouble. And that was actually what was happening. Doctors were calling Congress, people screaming at them that their patients were at risk. There was a big, big pushback to this sudden acceleration in the CDRs. And in fact, it turns out that the success rate on appeals was 69%. So people were getting thrown off, waiting, struggling, and then getting put back on. So Congress decided it better do something. And the Social Security Administration was feeling absolutely swamped. There were 23,690 separate lawsuits filed in supplemental security income cases in 1993 alone. And the SSA lost 18 class action lawsuits in that period. So Congress responds with a new statute. The statute is colloquially known as DEBRA. It doesn't actually have an E in it. It's the Disabilities Reform Act of 1984. And it changes the rules for stopping someone's disability benefits. The SSA must now demonstrate medical improvement on the part of the beneficiary, or that a clearly erroneous initial decision is being reversed. Those are fairly high standards. And the number of people getting cut through CDRs began to decrease and to stabilize. That problem seems to be over. One of the reasons I'm so interested in Deborah is Deborah had what I call a sleeper provision. The Congress noticed, as it was working on Deborah in 1984, that the mental health listings, and I'll talk about listings in a second, the mental health listings hadn't been updated since the Social Security, SSI was rolled out 10 years prior. And so it simply said to SSA, oh, and by the way, while you're at it, please update your mental health listings. Okay, all right. Two huge complications directly relevant to the children's program and to ultimately our dedicated account come from this CDR debacle that we just talked about. One is that one of those class action lawsuits is a case called Sullivan versus Zebley. And the Zebley case was brought by advocates in the Philadelphia Legal Services Office. I mean, another unexpected consequence of these CDRs was a lot of lawyers learned an awful lot about SSI in a very short period of time in order to be able to help these people who had been removed from the rolls. One group, the people in Philadelphia, kind of looked at the statute and said, wait a minute, something's wrong here. The statute said basically in the children's program, which is in a very brief part of the 1972 statute, it basically says treat children like adults in terms of assessing their disability. And it turned out that children were not being assessed exactly the same way adults were. And the folks at Philadelphia Legal Services said, hey, this is a problem. This is disadvantaging children. So let me talk a little bit about the disability process and particularly about the listings, okay? So if a person in your family had a disability and you thought that they should be entitled to SSI, and remember they have to have very limited assets and very low incomes, but if they do, then the next step, you first establish the low income and the low assets with the Social Security Administration. If it is established, you get handed over to a partner organization, usually referred to as Disability Determination Services, DDS. They're run by the state, so there's slight differences among them, but they will be the organization that will determine whether the person actually has a disability which is covered by SSI. They start with something called the listings, which is part of the Code of Federal Regulations, and they will say, if you have any of these things, then you are a person with a disability. If you don't have a disability that's on the listings, it doesn't necessarily mean you won't get benefits because and this is no longer true for children, but bear with me, there's a concept called comparable severity. If you have something not on the listings, but something that has severity comparable to things on the listings, then you would also be entitled to benefits. Okay, at the time of Zebley, that's as far as a child could go. If a child did not have a disability on the listings or one of comparable severity, the child's application would be denied. But for an adult, there was a third bite at the apple. For an adult, the DDS could say, okay, you don't have something on the listings, you don't have something of comparable severity, you clearly do have a disability, but is there work that you can do despite your disability, but given your work experience and your education? And sometimes the answer to that was no. And those adults could be placed on the rolls. There was no comparable assessment of what a child could do. Now, the Social Security Office said, but that doesn't make any sense. Children don't work. And what we're assessing with adults is their capacity to work. But the people who brought the Zebley case didn't agree. They agreed that there should be some kind of functional analysis of the child so that even a child like Brian Zebley, who did not meet the listings, and did not have something of comparable severity, should be able to be assessed to see how severe his limitations really were and how much that was going to affect his life. Well, the Zebley lawsuit was filed in July of 1983. It took a very long time to get through the courts because that's not really too surprising. There were lots of attempts to negotiate with the Social Security Administration to see if they could come up with something. But finally, the case went all the way to the Supreme Court of the United States, and it was decided in Brian Zebley's favor on February 20th, 1990. Remember, the Zebley lawsuit was filed in '83, and it was a class action. And the members of the class were children who had been denied benefits on or after January 1st, 1980. It takes 10 years for this thing to get through the courts. The Zebley class included 452,000 children. These were kids who had been denied benefits under an interpretation of the law by the SSA that the Supreme Court had just held was erroneous. Every one of those children got a notice saying, if you would like to have your claim re-adjudicated, please let us know. And 322,000 children said yes. So there was an enormous amount of re-adjudication. And though it was slightly less than 50% of children who were found to be entitled to benefits when the new rules were applied, it still absolutely exploded the rules. Now I'll tell you why I wanted to talk about Deborah and the sleeper provision. Deborah was told Deborah told the Social Security Administration to update the mental health listings, both for children and for adults. The thing that happened in between the initial listings in 1972, 74, and the updating, which is post-Zebley, is that the mental health profession had issued a new volume of the DSM. DSM is the Diagnostic and Statistical Manual, and it is where everyone in the mental health profession goes for information. It is absolutely there. I hate to use the word Bible, but it's the book that they use to understand mental health conditions, symptoms, treatments, et cetera, et cetera. In between the creation of SSI and the decision in Zebley, the DSM had gone from DSM-2, second edition, to DSM-3. That may not sound like a big deal. It's a big deal. DSM-3 is prescribed, and this is in the mental health literature, as, quote, a veritable paradigm shift in psychiatry. It had really gone in DSM-2 from sounding kind of like Freudian. There was a lot of discussion of neuroses and interpersonal conflicts, to sounding, my word for it is going to be very, very medicalized. DSM-3, we're now up to DSM-5, but DSM-3 is very medical. It gives very detailed descriptions of various mental disorders. It talks about tests that can be used to identify what a problem might be. It has things like likely age of onset for particular disabilities, so very, very medical. Another important thing, DSM-2, the old one, had 182 categories of mental disorder. That may sound like a lot, but DSM-3 had 265. So it's about it's more than a 40% increase. It's just a different worldview by the mental health profession of mental health. So when we get to the children's listings, right, which have to be for SSI, which have to be updated, now they have to be updated to match DSM-3. And so it probably won't surprise you that there were 4 categories of mental health issues in the original listings, and it almost tripled. It went up to 11. So there's much, much more recognition of the possibility that children might be disabled because of mental rather than physical disorders. And these two things happen within 2 months of each other, right? I have to catch my breath here. The changes that had to be made because of Zebley and the updating of the mental health disorders. The change that had to be made because of Zebley was to do something to look at a child's functioning as the statute looked at the functioning of an adult. And so what the Social Security Administration created was the Individualized Functional Assessment, the IFA. That's going to blow up too, but we will go on. All right, so that's the statute that we have in effect post-Zebley. We've got this new world of very expanded mental health diagnoses. And in January of 1994, we're going to bring in the media. We're already in 1994, remember, in 1996, I let you go. So we're looking at the media and some very not flattering depictions of the children's SSI program that were published in 1994. The Washington Post, a very reputable newspaper, began a series of articles in January, and their basic theme is that there are some federal programs that are wreaking havoc with the federal budget. The first one they talked about was Medicaid. But on February 4th, 1994, 2 journalists you may have heard of, Bob Woodward and Benjamin Weiser, published an article in the Post, and I'm going to read you the title of it, Costs soar for Children's Disability Program. How 26 words cost the taxpayers billions in new entitlement payments. The 26 words I wanted you to hear, because I'm going to get back to it in a minute. This article has 3 pieces, and I'm going to spend some time on it because I think it's terribly important. The first piece was an extensive interview conducted with a Dr. Nora Cook Porter. She was a pediatrician, and she had worked with DSS in Pennsylvania. She was actually being removed from her job when she reached out to Bob Woodward, but she was very concerned about the DDS role and the Children's SSI program. She told Woodward and Weiser that most of the children getting benefits did not, in fact, have a disability. I'll quote from her. She said, "Children who curse teachers, fight with classmates, perform poorly in school, are rebellious, are being diagnosed with behavioral disorders and given SSI benefits." That was what she said to them. She also claimed that many others working in DDS shared her ideas. And there were also reports that when the parents would get the checks because their children were getting benefits, they wouldn't spend them on the children. They would spend them to buy cars and take vacations. So that was the first piece of the article. The middle piece of the article actually goes back to 1972 and the drafting of the statute. And they interviewed a gentleman who was a staffer at HEW. Social Security was part of health, education, and welfare for a while. And this man, his name is Thomas Joe, very interesting guy. He actually was a person with disabilities himself. He was blind. And he had drafted the children's program section, most of which is covered in just 26 words. It basically says, oh, and by the way, treat children as you're going to treat adults under this new disability program. He agreed with Woodward and Weiser that he was just trying to sneak this thing through. The bill was 697 pages long, and he claims that no public hearings were ever held on the children's program. That's not correct. There were no public hearings in the House, apparently because Wilbur Mills hated public hearings and he held as few of them as possible. But there were public hearings in the Senate. And it's very, very clear that the 2 chairs, Mills and Long, disagreed about the Children's Disability Program. Mills was all in favor of it. He said these families need more and their children will have a better future if we give them more. Long's position was they need health insurance, but they get that under Medicaid. But finally, they agreed, and I told you this before, they agreed that they would not pass FAP, the Family Assistance Program, but they would add children with disabilities to SSI. So I think Mr. Joe was maybe slightly overstating his role in all of this, but Woodward and Weiser liked the idea, and notice this is their title, that 26 words are costing the taxpayers billions. Last story, and this is the one most relevant to the dedicated account. They interviewed a woman named Beverly Smith. Her 11-year-old son was one of the Zebley plaintiffs. He's described in their article as hyperactive and was found to be entitled to benefits on the re-adjudication post-Zebley, okay? If you apply for SSI benefits and you are approved, you don't necessarily get your money right away. And if there are back payments due because of various delays, you are entitled to get those back payments. With Zebley, some of these kids should have been adjudicated as having a disability 10 years before they actually saw any money. Remember, that class went on for a very long time. So Ms. Smith actually got a check for $13,000 for her son. And if that weren't complicated enough, if that $13,000 sat in the bank for 6 months, her son would lose his benefits because he would go over the asset ceiling. So under the statute, she had 6 months to spend down that amount, or her son could lose his benefits. It's a little more complicated than that, but not a lot more complicated. So Woodward and Weiser spend a lot of this article describing her spending spree. Forgive me for throwing in something personal and gendered, but only a man could have thought that all of these things were a mistake. But going on, Ms. Smith did, in fact, own a house. She worked part-time as a custodian in a bank, and $13,000 was 1.5 times her annual income. Her house had a leaky roof, which she hadn't been able to repair because she didn't have the money. And the roof leak was so bad that it actually rotted out some of the floors. She took the $13,000, got her roof repaired, and her floors repaired. She had some money left after that. One of the things her son liked to do was start fires. and he had done that more than once. And so she had a new stove put in with all kinds of safety features to try to make it safer for her son, who was so attracted by fire. She did buy some things that I guess you could say are a spending spree, but this is the one that I think of as gendered. She bought a washer and dryer. She'd never had them. She had to go on the bus with her hyperactive son to the laundromat. And she thought, you know, a washer and a dryer might really improve everybody's quality of life. She did buy a used car and a television, and she bought her son a computer, his first computer. And as other people on this call might, Zoom might be able to tell you, doctors will specifically recommend computers for some kids with attention deficit hyperactivity disorder. It somehow helps them to focus and helps them to learn. So that was the spending spree. But the article was not meant to pat Ms. Smith on the head for what a good job she did, spending down her money so her son didn't lose his benefits. Instead, Woodward and Weiser end the article quoting a psychologist who sometimes worked with DDS, who said, parents are receiving a cash award for having achieved the problem. And copies of this article were distributed to every member of Congress, not by the Washington Post, but some folks in the House, members of the House, who really felt very vindicated that this was what others were seeing in the SSI children's program, okay? So that's February. In October, we have another big media piece. This is on ABC's Primetime Live, and the segment was called Crazy Chicks. It was hosted by Chris Wallace, Diane Sawyer, and Sam Donaldson. Again, journalists everybody's heard of. The same pediatrician, Nora Cook Porter, was extensively interviewed by Chris Wallace. And this time she comes up with a number. She tells him that fewer than 30% of the children on SSI deserve their benefits. She also says that the benefits are so generous that if you have several children with disabilities in a family, the family could, quote, buy a Mercedes. The remainder of the interviews all take place in Arkansas. And it turns out that there was a state legislator in Arkansas who was very interested in this program and very concerned by this program, tried to get the Arkansas legislature interested in it, but they weren't. But when he went to the Arkansas Democrat Gazette, there were some reporters there who were interested. They made some inquiries, and Chris Wallace and Diane Sawyer and Sam Donaldson kind of followed up on that. And a number of teachers and school counselors said they did think that parents were coaching their children to act as if they had a disability so that the family could get a benefit. And they were telling their children that they needed Crazy Chicks, which is where the name for this came from. Interestingly, when they interviewed people in disability determination services actively at work in Arkansas, more than one said, it doesn't happen in this office because we're really careful, but we know it happens someplace else. So this was Crazy Chicks, and Crazy Chicks was aired before all of the members of Congress who wanted to come and see it. So those two pieces, both coming out in 1994, were very important in painting SSI kids in a pretty bad light. Okay, we can go off to Congress. We can finish 1994 and get ourselves to 1995 and 1996. So in 1992, I just backed up a little bit, Bill Clinton had been elected president, and one of the things he pledged to do was end welfare as we know it. By welfare, he meant AFDC. He wasn't talking about SSI. But what just happened with this bad publicity in 1994 is some of the antagonism, and there was a lot of social antagonism towards the AFDC program. Some of that's now catching the kids on SSI. Bill Clinton was not talking about SSI when he promised to end welfare as we know it, but he was talking about changing benefit structures because they were too costly, and maybe they were even encouraging negative behaviors. All right, at the time that Clinton was elected, the Republicans were in the minority in the House, but they were very, very focused on welfare reform, and they were working hard on it. In fact, in 1994, in the next midterm election, Newt Gingrich, who was then in the minority party in the House, and a bunch of other Republicans in the House and candidates for the House introduces the contract with America. They promised voters that if they, the Republicans, took over the House, they would balance the federal budget, I think in 10 years, write a large tax cut that would benefit lots of folks. And they were going to pay for these things by stopping the waste in welfare. They didn't, again, specifically talk about SSI, but if you think about this as a train, the caboose on this train, the lead of this train is the AFDC, the caboose is kind of SSI. So that was September of 1994, Gingrich and the contract with America. October is when Crazy Checks airs, and in November, the Republicans took control of the House. And in January, when the new Congress was sworn in, Newt Gingrich had become the Speaker of the House. And the Republicans go right to work on trying to find ways to cut benefits so they can deliver on their balanced budget and their problem of a tax cut. So they did a number of things. This is going to lead us right into the dedicated account, I promise. It's going to take a lot of different pieces of legislation. I don't think I'm going to go through them all. I think I can make it a little shorter than that, but here's what happened. The first piece of legislation that the Republicans are working on would have made drastic cuts to SSI. Basically, there would have been no more cash benefits, except for children who were living in institutions or would have to be placed in an institution if their family lost their benefits. For all other children, cash benefits are over. What Congress was going to do instead is give some money to the states, and it was going to be about a 25% cut in what was being expended at that point in the existing program. But the states could apply to get some money, 75% of what had been coming from the feds before, and they would have a lot of leeway. They could basically design any sort of program they wanted, what children would qualify for benefits, what kind of benefits would be available, but there was one rule: no state could give a cash payment to a family on behalf of a child with a disability. So this was pretty draconian. I'm going to skip a little bit and merge a little bit, but the basic answer is Bill Clinton vetoed this bill. It had lots of other provisions. I just want to stick with SSI. When he vetoed the bill, it's like 82 points that he made on why the bill was not going to ever get his signature. But he mentioned specifically the damage to children with disabilities. And at the same time that this was going on, the Urban Institute was working hard to get some data on how these various bills might actually affect children. And one line of theirs really stood out in the public's mind, and that was that 2 million American children would fall below the poverty line if what the House wanted to do, the Congress actually wanted to do, with cutting SSI and AFDC. Okay. I'm going to leave the House, I'm going to go over to the Senate, and I'm going to introduce you to the man who wrote the provision that became the dedicated account. This must mean we're going to get there Sunday. The man was Senator Robert Dole, who was also a person with a disability. And he had been worried since Zebley came down about the large back payments. He knew they just weren't going to look good. And he had suggested and actually wrote a bill which would have allowed a parent getting one of these back payments to create a trust. And any money in that trust would not be subject to the spend down requirement. So it would remove the problem that Beverly Smith had faced with get rid of this money now or your son loses his benefits. However, as his staff researched this, they found that the cost of the trust, you've got to get a private attorney to write it, a private attorney to administer it, it was just cost prohibitive. Most of these families would not be able to afford it. So he gave up that piece, but he never really gave up the notion that some way for a parent to elect, to put money aside would be beneficial and would really make this a better program. So as the House Republicans are back working on a newly revised version of their bill, since Clinton vetoed the first one, Dole is trying to figure out what he could do to create something that would be like a trust, but not a trust. And he comes up with a good idea. When a child gets a disability payment, it's deposited into a bank account, which his personal representative, virtually always his parent, opens for him. Dole said, I got an idea. If the parent elects, she can open 2 savings accounts. And we will take the back payments and put them in this special dedicated savings account. The dedicated savings account won't cost the mother anything. It just goes into a bank account. And the protections that a trustee might, supply, if this were a private trust, can be covered by legislation. So Dole came up with just a few things that this money could be used for: education and job skills training, special equipment or housing modifications, specifically related to and required by the nature of the child's disability. Sorry, but that was Robert Dole's language, or appropriate therapy and rehabilitation. The really important thing about Robert Dole's idea is not only that it's probably a good idea, but it was completely voluntary. The goal here was to empower the parent. So suppose you had a child who had a brain injury at birth, and it might take a long time to understand how much function the child might have lost from that brain injury. And maybe the child, for whatever reason, has a holdup in payments and winds up with a large back payment. The parents might say, we'd like to wait and see what kind of accommodations our little one is going to need. But if we don't spend the money and we lose the benefits and the Medicaid, that's not going to work for us. So Dole would have empowered parents in that position or other similar positions to elect to have this back payment put in this dedicated savings account, no costs incurred, some limitations on use, some pretty severe limitations on use, but no parent had to opt for it. Okay, back to the House. We're almost there. The House is seeing that maybe President Clinton isn't too keen on having large numbers of children lose their SSI benefits. So it stays with its two-tiered idea. It still says that only children who are in institutions or at risk of institutionalization are going to get full benefits, but all of the other children will get 75%. And it will still come as a cash benefit. But he didn't like that either. So this bill also is going to get vetoed. Ultimately, and this is sort of funny, especially if you spent like a year reading through all of this, the Senate, the House basically on the SSI provisions, still remember the engine on this train is AFDC. They are trying to get rid of AFDC and to change it into just what they were talking about for SSI. That is, rather than a benefit to each individual, a bucket of money for a state, not an open bucket. And the state gets to decide exactly how it is going to deal with poor children or deal with children with disabilities. So they get off that train, they stay on it for AFDC, but they get off it for SSI. And they just cut dramatically the number on the benefit rules. That doesn't work. They go back and they say, maybe Bob Dole had a good idea. So they go to a bunch of things that were in Bob Dole's plan, like let's eliminate the individualized functional assessment, the IFA. And there is a Office of the Inspector General report about coaching in which they say, we don't really know if there's any coaching out there, but we think the IFA is a big mistake. And if you want to reduce the number of children on SSI, get rid of the IFA and have another means for deciding if a child is entitled to benefits. That was Bob Dole's idea. Get rid of the IFA and instead create a definition of disability that is unique for children. Don't try to make the children mimic the adult standard. So I'll just read you briefly what he said. Under Dole's proposal, a child must show a medically determinable physical or mental impairment, which results in marked and severe functional limitations and can be expected to last at least 12 months. That replaced the IFA. The CDR process was kept, but it was kind of cleaned up in Dole's bill. And then he creates this optional dedicated savings account. When the House, rather desperate for a victory at this point, and seeing that Clinton is not real keen on cutting benefits to children with disabilities, basically adopts Dole's bill. It's fairly toothless in a lot of ways. It probably does something positive in getting rid of the IFA. But in the conference committee, so when there are conflicting pieces of legislation on the same topic, one in the House and one in the Senate, a conference committee is named with members from both the House and the Senate, and they sit down and figure out how to make a unified bill that they think both houses of Congress can pass. So here comes the new bill, and the House and Senate are a little bit different. The Senate still has Bob Dole's optional dedicated account. But the conference committee, my view is just trying to salvage something that looked like it was restrictive, creates a mandatory dedicated account. So if you are going to get a back payment more than 4 times the federal benefits rate, so more than 4 months in back payments, you have to open a dedicated account. You have to deposit that money into the dedicated account. And they increased the number of uses for the dedicated account, but not by a whole lot. I know there'll be much more discussion of this later, but there are only the following things that that money can be spent for: education, job skills training, personal needs assistance, special equipment, housing modification, medical treatment, therapy or rehabilitation. And then there's a piece at the end that says, or any other item or service the commissioner deems to be appropriate, provided it benefits such individual and in some cases is related to the impairment of such individual. That's the mandatory dedicated account. It came out of the conference committee. They don't explain in the conference committee report why they were doing it, but they definitely take Bob Dole's idea, and here's the good things about it: it's free, and it protects the money from pushing the child off benefits because he has too many assets. But it's very, very, very restrictive. And what this bill has now done, and this bill becomes law, is create the dedicated account, whether the parent wants it or not, if it is just 4 times the benefits that have been backed up. It's not an enormous amount of money. I tried not to have too many pieces of paper in front of me as I did this, but when the Social Security Advisory Board wrote its statement on the dedicated account in 2019, it said that at that time, you would be required to open a dedicated account if the child was owed $4,626 in back payments. That's not nothing, but it's not a lot. The other thing I will mention, and then I'm going to stop talking, is that in this very same bill that creates the mandatory dedicated account and gets rid of the IFA and does some other things with children's SSI, the the Congress said that if any adult or child is owed more than a certain number of back payments, they get them in installments. And that didn't used to be true. Ms. Smith got the whole $13,000 at once. Now, most large back payments come in 3 installments. Some people think, well, why didn't they put 2 and 2 together and say, why do you need a dedicated account if we're never going to have these huge back payments again? But they were under a lot of pressure to finish this bill. And again, I would urge you, this is the last thing I'm going to say, to remember that driving the train is AFDC, not SSI. SSI is the caboose. It basically did pretty well when you figure what it was up against with the first round where everybody was going to lose their benefits. But it got stuck with this mandatory dedicated account, which other people are going to talk about, but I don't favor. I'm done.
Well, thank you so much, Mary. That was very comprehensive, and we really do appreciate it. I think what we're going to do is we're going to move to James Klein because we're under some tight time frames, time limitations, but we'll get to questions after Jim. So hold on to your thoughts for those of you who have questions. So what I'd like to do now is turn the program over to Jim Klein from Social Security's Office of Inspector General, and he's going to be presenting on the Office of Inspector General's audit and oversight work on dedicated accounts, including its most recent September 2019 report. So, Jim, you want to take it away?
I do. Good morning, everyone, and at least good morning for me, and good afternoon, I think, to most folks on the call. I appreciate the invitation to participate in the discussion about dedicated accounts for SSI recipients. And what I'm going to do today is I'm going to provide you with a summary of the results of 2 Office of Inspector General audits concerning dedicated accounts. And these audits focused on SSA's policies, procedures, and practices when dedicated account requirements apply. And I am also going to respond to some questions that you submitted concerning these reports. And lastly, I believe you do have copies of the reports today. So as Kim mentioned, I'm going to talk about a September 2019 report on dedicated account underpayments. payable to children receiving SSI. And this was actually an audit that was a follow-up to a November 2010 report on the same topic. And then the second report I'm going to talk about briefly is an August 2007 report on SSA's monitoring of dedicated accounts for SSI recipients. So let me jump into the September 2019 report. For this audit, we determined whether SSA had adequate controls to ensure it paid dedicated account underpayments to children receiving SSI. And just a little bit of background, our audit focused on SSI recipients with underpayments that required a dedicated account that SSA had not made any payments. And that is, the rep payee basically had not established the account. So therefore, our audit by design was focused on a population that was more likely to be problematic. We did not review dedicated accounts that rep payees had established and that SSA issued some or all of the underpayments. For example, our audit did not include a review of approximately 42,000 recipients that SSA was making installment payments to a dedicated account. What our audit did look at was a population of approximately 21,500 recipients, again, whose dedicated accounts had not been established and SSA made no payments. And from that 21,500, we reviewed a random sample of 100 recipients for review. And our findings, what we found is for the 100 recipients in our sample, SSA had not paid 65 recipients dedicated account underpayments totaling $363,000. On average, it was about $5,600 a person. And actually, when we looked at this a little bit further, it turns out 8 of the 65 did not even meet the requirements to establish a dedicated account. When we project those sample results to our population, we estimated that SSA had not paid approximately $78 million to 14,000 SSI recipients. What I want to do now is just go over a little bit of the characteristics on the types of payees for the 65 recipients in our audit. And when I looked at your 2019 statement on dedicated accounts, I think the percentages are really close to what you were disclosing in that report as well. So for the 65 recipients, 5 had organizational rep payees, or 8%. 4 had a relative that was the payee, 6%. 4 had a grandparent who was a representative payee, another 6%. And 12, the father was a rep payee, 18%. And 40, the mother was a representative payee. So basically 92% of the payees were relative or closer to the child recipient. And we did also a little bit of work to follow up on our 2010 audit. We reviewed a random sample of 30 recipients from that audit, and we found that SSA still had not paid dedicated account underpayments to 18 of the recipients, 60%. So what I'd like to do is get a little bit into the reasons we found why SSA had not paid dedicated account underpayments. And of the 65, 29 payees simply did not comply with the requirements to establish a dedicated account. And, you know, that's a challenge. And we've got some information from SSA on this, which might give some insight on why this was occurring. SSA indicated that parents of SSI disabled children may be encountering difficulty in opening bank accounts. They were stating that some banks refuse to open an account with the payee's name because of the payee's poor credit risk. And when a payee does not basically comply with the requirements, SSA policy really leads their employees to looking for alternative payees. However, SSA did tell us that removal of payee in these situations was not always in the best interest of the child. generally, and as our stats show, almost always these are payees, is a parent living with the child and is in the best interest and is in the best position to know of and attend to the child's needs. So therefore, SSA would keep these on and they would remain as the preferred payee. I think in the end, these 29 cases like this will get resolved, but some obviously are still falling through the cracks. Another 21, there was instances which SSA employees simply did not do required follow-up on their system diaries or alerts. There were 11 instances in which there was no evidence that systems of diaries and alerts were even generated or produced to ensure that SSA employees followed up on these accounts. And then lastly, we identified 4 instances in which there was no evidence that SSA informed the payees of the existence of dedicated funds and the need to establish a dedicated account. We made 3 recommendations to SSA in this report, and basically the first 2 dealt with taking corrective actions on the sample cases that we identified and also taking corrective action on the larger population of SSI recipients with unpaid dedicated accounts. And then we had a third recommendation that dealt with improving controls to ensure it timely pays dedicated account underpayments, such as establishing management reports, ensuring that it retains diaries, and or adding automation, which was discussed in our report. SSA agreed with all 3 of those recommendations, and this is back in September of 2019. So you had a number of questions related to the 2019 report. First question dealt with, you stated, the 2019 report included a subset of cases present in both the 2010 and 2019 samples with improper withheld underpayments. What factors have limited SSA in establishing adequate controls to resolve these protracted issues over the years? And you're correct. In our 2010 report, we did have a recommendation that SSA needed to improve controls to ensure that it was properly paying dedicated funds. In May of 2013, SSA reported that its SSI modernization effort would address our recommendation. SSA also stated that it would be part of a multi-year effort for SSI modernization starting in fiscal year 2013 and going through fiscal year 2017. We did see that SSA did implement some system changes to address our recommendation. For example, one of the issues dealt with certain alerts and diaries for recipients with dedicated funds on prior and previous SSI records. They did make a change for that. However, our 2019 audit found that these system changes were just not enough, and they did not fully address the conditions we identified in our 2010 report. So, which leads us to the next question, and what is SSA doing now in response to our 2019 report? You asked what actions has SSA taken in response to OIG's recommendations included in the 2019 report, and do they sufficiently address the issues raised in the report? And I'll say to a large extent, the jury is out on that. SSA reported that it took corrective action on all of our sample cases identified in the 2019 audit. SSA also reported that it is continuing to identify the remaining population of SSI recipients with unpaid dedicated account underpayments. So those are basically addressing our first 2 recommendations. Concerning our third recommendation with respect to improving controls to ensure SSA timely pays dedicated account underpayments, SSA reported that it's still evaluating enhancements required to implement this recommendation and is determining whether they are feasible. So, and that was information we got from SSA within the last few weeks. So it's still an open issue. You had a question asking whether we have conducted a follow-up analysis of these issues during the pandemic. And we have not, and at this point, we do not have anything planned at this time. You had a question, how, if at all, has the pandemic influenced the administrative challenges outlined in the 2019 report? I'm sure it has had an impact. I don't know that I can quantify that impact, but I think it is a couple things that I'd like to note of importance. SSA has made no policy changes concerning dedicated account funds during the pandemic. And in fact, SSA instructed its employees to follow existing dedicated account instructions during the pandemic. And that is, any request for use of dedicated funds during COVID-19 or the establishment of dedicated accounts must still meet policy criteria for the use of funds and establishment of accounts. You had a question whether SSA's IT modernization plan adequately addresses the systems issues such as lack of diary alerts for outstanding underpayments highlighted in the 2019 report. And you're asking, are other changes necessary to ensure SSA has adequate controls? And if so, what they are and what would be needed to do so. We looked at SSA's IT plan. It does not specifically address systems issues identified in our 2019 report. However, as I mentioned previously, SSA just informed us within the last few weeks that it is still evaluating our recommended enhancements to determine whether they are feasible. So again, it's still an unanswered question at this point. So the next report I want to talk about briefly is an August 2000 report on SSA's monitoring of dedicated accounts for SSI recipients. And this report is a bit dated, but it generated a question from the board. So I want to just kind of briefly go over what we found in this audit. For this audit, we determined whether SSA complied with its policies and procedures regarding the monitoring of dedicated accounts for SSI recipients. And for the audit, we identified a population of approximately 17,000 recipients with dedicated account balances. And from that population, we selected a random sample of 305 recipients for review. Our overall findings were that SSA was unable to provide accounting forms for more than half, 154 of the 305 sampled recipients. So we couldn't even determine whether, and SSA could not provide us evidence that they had sufficiently monitored those funds. For the 151 recipients that SSA was able to provide accounting forms, 31 had questionable and incomplete responses that SSA policy required that its employees follow up to resolve. And those 31 instances, the employees did not do the required follow-up actions. The questions that came from the board on this report really dealt with question of the prevalence of misuse or fraud related to dedicated accounts. And I guess the best information I can tell you, or the best I can maybe point you to, is I think SSA is in the best position to give you perhaps information on data related to misuse or potentially fraud for dedicated funds. As you know, SSA is required to report to Congress annually on the results of its site reviews of repayees. And during these reviews, SSA's contractor now is required to examine a payee's use of dedicated funds. I reviewed SSA's most recent report to Congress and found that it did not include any information on those dedicated funds. However, the data behind this report may have some information concerning misuse of dedicated funds. And then SSA also might collect data when it detects misuse of dedicated funds during its periodic redeterminations for SSI recipients. That's another possible source for data on misuse of funds. And certainly, should we do future audit work concerning dedicated accounts, we would, this is something we would certainly consider looking into, and would collaborate with our Office of Investigations to see what information they may have related to fraud related to dedicated accounts. So with that, that's kind of my brief summary of those two reports. And I can take questions now, but it sounds like, Kim, you want to defer questions till maybe a little bit later.
Nope, you're not off the hook yet. We're going to
that's fine.
a couple of questions now, and we're supposed to do a break at 2:30. So I think we've got some time for some questions. As moderator, I'm going to use my moderating title to go ahead and just ask a couple of questions first before I turn it over to our board members. So actually, the first question I'd like to ask, direct my question to, is Mary, and that is, this is a very broad question, but I think it's just, it fits the ticket, and that is, are dedicated accounts serving their intended purpose as laid out in the legislation?
You're on
Actually,
mute.
you're muted, Mary.
Sorry, no.
Okay.
And one of the things I think that Commissioner Barnhart may want to talk about, but administering these things isn't free. She estimated at one point it cost $5 million a year to have dedicated accounts. And I provided to the board a short synopsis of a bunch of studies, very much focused on questions about coaching, where the kids being taught to behave badly so they could get crazy checks. And no one is ever able to document it. Now, as they say, it's hard to document coaching. If parents are having secret conversations with their kid, it's going to be out of earshot to everybody else. But part of what seems so strange to me is that, these kids are getting benefits after going through several levels of examination, and several people who have no particular incentive to find that a fraudulent case should go forward are finding in the child's favor, or they don't get a dedicated account and nothing happens. I think I can say that a little bit better, so give me one more shot at it. This is not as though somebody gets to apply for something and they don't have to establish any proof. They do. So in order for children to be coached onto benefits who don't really have a disability, you not only need to assume that parents are being fraudulent, you have to assume that none of the monitoring is working. So if it's in the initial situation, you have to assume that DDS didn't do a good job and let a kid on who really doesn't belong there. And in terms of the dedicated account, if we don't think the parent was committing fraud in getting the child on the benefits, I'm not sure why they would be committing fraud later on. And again, I've submitted already to you a set of reports, some by the OIG, but also by the National Institutes of Medicine and the National Institute of Social Insurance, in which they say this has really been overblown.
And then could you also just briefly talk about your understanding of the statute and whether SSA, obviously changing the law is hard for all kinds of reasons that have nothing to do with the policy itself, oftentimes. And I'm wondering, based on your experience, is there more that SSA could be doing under the statute, either through regulation or procedures, to make the process easier for parents?
It may be that Tara Doucette or Linda Landry would be better to respond to that, because we're now getting down to the very procedural level. I think this is true, that the requirement that a spouse who is a representative payee make a report on a regular basis about the use of funds, I believe that's been waived. And so one of the things that I don't know as much about as I should is how much of the reporting that's required could be done away with, because it's very, very burdensome for the parent and for the people working in Social Security. I will give you one anecdote, but it comes from a person that had a fellowship at Greater Boston Legal Services for 2 years. I worked very closely with her. And in all of that time, she only had one client who had automated banking. And that's, when you think about very poor people, that's not unusual. So keeping records can be very hard, especially if you're talking about very, very poor families. They have to move more often than other people. And so keeping records and showing that you're doing the right thing, I think it'd be hard for me, but for somebody who doesn't have automated banking, for somebody who has to make several moves sometimes in the course of a few years, I feel like this idea came in at the last minute. And it sounded good to Congress because it looked like we're being a little tougher on them. And remember, this is a period of awful media coverage. And nobody sat and thought about, because there wasn't time, how is this actually going to be implemented? Who's going to watch over this? How do we make sure that only these categories of expenditures are being made? So I think it's not very workable. And the thing that puzzles me terribly is once they decided, Congress, to do installment payments, why do you also need a dedicated account? If the amount of money that's coming into a parent's hands at any time is relatively small, I don't think you need to worry about the shopping sprees that so upset Woodward and Weiser.
Mm-hmm. Great, thank you. And Jim, I just wanted to ask you a little bit, I know you just talked about it briefly, but I'd like to see if you have any other thoughts. As SSA reviews parents and rep payees spending of dedicated accounts, they talk about misuse and they talk about misapplication. And then there's also this more global term out there, as you well known, called fraud. And I'm just wondering, is this an area that the IG has seen any complaints about through their hotline? Or just from any other outside sources? In my experience, at least, usually if there's some blatant, problem with a particular policy, people will go ahead and report it.
Yeah, Tim, not that I'm aware of. I'm certainly in the best position to know that for sure. So I could follow up with our hotline to see if they have seen anything. Personally, I'd be a little surprised, but, again, I'm not in a great position to know with certainty whether that is problematic.
Mm-hmm. And then maybe you could provide just a little bit of insight for us as we think about all of these issues going forward. One of the things the board consistently talks to SSA about is collecting the right data ahead of time. When they set up new programs, to make sure they're collecting the right data so that they can monitor how policy is actually being implemented and what needs to change. You talk a lot about controls, and could you talk a little bit about the process that SSA uses, and I don't know if that's through a systems group or what have you, in terms of priorities for what system changes are going to get made, and whether that's controls versus certain data point collections, and how that works in terms of establishing priorities.
Yeah, I know Social Security does have a group that does prioritize IT projects. We have a separate dedicated systems team that might be in a position to address that. Looking at this, again, this is my personal opinion. It's a vulnerable population. It's an important population. It's not huge in the SSA world, so it might not always meet that cutoff point where SSA is determining, what are our priority projects. This recent audit, we're talking about 14,000 recipients. $78 million, that's a lot of money to those people. I'm just not sure if it's, where it fits in SSA's threshold for IT priorities. Mm-hmm. And I also think, and again, I'm giving my personal opinion, the systems can do so much. And at some point, an employee needs to do the right thing, and managers need to oversee their employees to make sure they're doing the right thing. And I think that may be applicable with this issue and what we found in 2019.
Sure. All righty, so we can open it up to first maybe board members for any questions the board members may have.
So I have a question about one of the issues or comments that presenter made about the types of expenses that are allowed under current law for spending through dedicated accounts. And the comment was that these allowances for spending items are very restrictive. So are there particular ways in which those conditions would be expanded or should be expanded in your view?
That question's directed to me?
Yes.
Okay. Well, if the statute's going to be changed, of course, Congress is going to have to change it.
No, but it's your view about how, in what directions, what particular additional items should be included in that list?
I guess I would, well, the problem with education is that most of these kids go to public school. The problem with talking about medical care is most of them, fortunately, are on Medicaid. So I guess I'd need to think a little bit more about what is it that should be in this restricted fund, but easier for the child to use. I mean, honestly, some of the stories that I tell in the long version of my paper, there was a mother who brought a child who had a birth injury home. And he's this tiny little baby. The mother's barely able to pay her rent, and she can spend money in his dedicated account on education while he's an infant, job skills, special equipment. What she really needed, I mean, I don't mean to sound silly here, but she needed infant formula. She needed diapers. She had to take him to many, many medical appointments, but she wasn't allowed to use that money to transport herself. She didn't have a car, to transport herself to medical appointments all over the place. It was Boston in the winter, and she wanted to buy him a snowsuit. So she had all of these expenses, and none of them could be touched because they're not in the restricted categories. So I think what I'm really saying to you is any idea of restricted categories, if there's not the option, as Senator Dole would have had it, for a parent to say, yes, this is a good idea for me, or this isn't, we're just going to miss so many people. One of the things from last year's board program statement was that there are, what page is this on? 26% of dedicated accounts never get touched. It isn't that the parent wouldn't like the money, it's that their life and what this money is available for just don't mesh at all. And I think that is, again, part of the fact that Congress didn't think about this. Senator Dole thought about an optional account. Congress just made it mandatory and didn't think it through.
And Jagdish, I just wanted to mention that at our second panel, we actually asked the panelists to submit their suggestions for expansion. So we'll be talking about that. In addition, we'll be talking about that piece again.
Thank you.
Sure. And I just wanted to, I saw Joanne's name pop up real quickly, and I know she's in a car traveling over the mountains, and I just wanted to be sure, Joanne, was there something you wanted to say? Okay, I'm going to call it no. Nancy?
Yeah, it looks like Joanna's muted. So, and Joanne, if you can hear us, keep your hands on the wheel if you're driving. We don't.
Okay.
We don't.
Can you hear me now? We can actually. We can hear you
now.
now.
There you go. Okay, Joanne.
I had it muted because I'm going 80 miles an hour up 81. It's kind of noisy in the car. So I was listening to both of the wonderful speakers. Thank you both for your presentations. I had a question where I'm really exhibiting my ignorance here. As far as expenditures under dedicated accounts, do they have to be current or prospective expenditures, or are they allowed to pay for things that have already been paid for by the parent? What brings this to mind for me, particularly now, is given COVID, it's likely this year created a situation where parents may have had to spend money on things for their children, maybe under the allowable reasons, before the child was deemed eligible. And as a result, now are in debt or can't afford to get their roof fixed or whatever. So can you back pay the parents for things that they spent as long as they can provide documentation?
I would think so. And again, there may be that the people who do this every day, rather than writing articles about it, could give you an absolute answer. I know parents, many parents worry a lot about misusing funds, because if they misuse funds, they have to pay it back out of their own pocket. And sometimes they just can't think of a way to do that.
Hey, Jim, do you know the answer to that question?
I don't, but I do know, not for other expenses outside of dedicated funds, I know there is provisions in SSA policy that allows reimbursement to the payee for previously incurred expenses, but that's more general, not specific to dedicated accounts. I don't know whether that policy applies to dedicated funds as well.
Okay, or David from that one?
And Kim, I had one other question, which really was kind of an add-on to what you asked, and that is, I heard what the first two areas of allowable expenditures are, education and medical. What was the third? And is there any flexibility there in how SSA can interpret that?
I'm looking for my notes so I don't get this wrong, because there are different versions of it. Education or job skills training, personal needs assistance, special equipment, housing modification, medical treatment, therapy or rehabilitation, or any other item or service that the commissioner deems to be appropriate. And then there's some limitations on that.
Yeah, that's the huge flexibility one. Any other one the commissioner deems to be appropriate. That seems to me to leave it wide open for a rule or regulation coming from a commissioner, but that's how I would have interpreted it. If said someone raised this issue and focused on dedicated accounts when I was there. So that was my question. Thank you. Thank you both.
Great. Are there other questions from board members?
This is David. I didn't do the *6. Can you hear me now?
I can hear you now.
Okay. So back to that question about prospective or retroactive. There is sort of a catch-all where it talks about emergency exceptions. We can determine that in emergency situations, if there's an where the unavailability of the dedicated account funds would cause problems with basic living expenses or may result in the child becoming homeless or malnourished, then we can approve the funds. So that could apply in that situation.
Great, thank you.
We've actually heard that there are some SSA offices where you have to have an eviction notice in your hand to have funds released for paying rent, because that's not normally covered. So good, but maybe not so good.
And
There is discretion.
Mm-hmm.
Okay, are there other questions from board members?
Yeah, Kim, I have a question for Mary. First of all, I found that history really informative, so thank you for all that detail on it. I'm intrigued that I know that both Democratic and Republican administrations have called for just eliminating dedicated accounts, and you indicated that was what you were interested in. Jagadish gave one alternative, which is just to make the funds more available. What do you think of keeping the dedicated accounts but making them voluntary, the way that, and maybe making them less restrictive as well as an alternative?
I think that's fine.
Is there a reason? I guess the question is there a reason to keep them if they were voluntary, or is it just it takes too much administrative cost and time, and it's just not worth it?
I guess I don't know about the administrative cost and time. The only figure I have, and I'm sure she's correct, is Commissioner Barnhart, who said it costs $5 million as currently set up. I think Senator Dole had a really good idea. And when I think about that child who came home from the hospital and it was just so unclear how profound his disability was going to be, you might want to put money aside if this mother had been a little bit wealthier. Maybe if you had owned a house and your child wasn't going to be able to walk, which you don't know yet, you would want to make housing modifications. But because of the spend down policy, you couldn't maybe wait and see how the child developed. It's not necessarily a bad idea. I wonder how much it would cost. But I do think, you know, this dedicated account came along, mandatory dedicated account, at a time when there was some very bad publicity about SSI, which none of the deep studies later really very much supported. And when Congress kind of quickly said, oh, we like this idea of a separate account, let's just make it mandatory. I don't mean to say that I would want to do Congress's work. They had a lot of work to get done, but I don't think a great deal of thought was put into this. And if it were to be made optional, that would have to go back to Congress, right? So if we're going back to Congress, I guess I would rather just say, do we really need this at all? Especially because we now have installment payments. They're a whole lot easier for SSA to manage than monitoring a dedicated account. And if you wanted to create a statute where if you are owed up to X dollars, you get 3 installments, but if it's this much, it has to be 6 installments. The installment payments I like a lot, and they seem to me like once it was set up, they would be easy for SSA to administer.
Thank you.
Kim, I just had a quick, this isn't so much a question as maybe a semi-question comment, is that going back over the history, I was a legal aid lawyer in the early 80s.
Oh, wow.
So many people were thrown off of SSI, and watching a large portion of the population who were too disorganized, frankly, to even reapply. And what happened at the same time that federal support for housing was so dramatically reduced, in my mind at least, brings us to today in many ways. And so this seems, for me, very topical going through the history. I was interested in one of the comments online, which was about ABLE accounts, and it seems like there is somewhat of a parallel in terms of creating voluntary accounts for people to put money that then can be available for costs. The last thing I was going to mention, and maybe you could comment on it, is that I saw something very similar in terms of reaction to publicity happen in the area of respite services for kids with intellectual developmental disabilities, where there was a great press coverage of families that were taking vacations who had the enormous burden, or at least challenge, of taking care of kids with severe disabilities, and having an opportunity to take a break from that and have some help allowed them to fulfill a service that traditionally, as you pointed out, used to be provided by state institutions. And when the state itself in those institutions and parents stepped up, of course, you know, I thought it was a reasonable policy option to give them a break in terms of providing that. And so I see real parallels in those areas. So I guess my question is has there been a major publicity effort in order to bring those sorts of perceptions forward and experiences forward, since it seems like Congress reacted very much to publicity about fraud and abuse? Is that something that advocates can consider in terms of at least maybe getting regulations to change, administrative policies to change, and getting Congress to move is something I can't even contemplate. But I'm just wondering if anything of that sort has happened.
I know nothing about that. I think it's a wonderful idea. The Institutes of Medicine, which was the last group to evaluate the program and see whether they thought that the issue there was there overdiagnosis of mental disabilities in children applying for SSI? Was it way out of sorts with the overall diagnosis in the general population? And they said no. And they said very, very clearly that poverty is itself a pre-existing condition. That if you are growing up in poverty, the likelihood that you're going to suffer any of a range of disabilities is high. Where the middle class family that's doing okay, they may have a disabled child too, but the likelihood is very, very different. I'm a scholar. I write sort of long, boring treatises. You don't want me up there, telling the public, think about this differently. But I think you're exactly right, that if more of the stories of how kids are helped by this program and the things that they can do. And, you know, we've all seen this, those of us who are a little bit older, not to make any assumptions about you, sir. But the people who would have spent their life in an institution if they were born in 1950 now have jobs. I mean, there are lots of things they can't do, but they're, you know, bringing the shopping carts back in the parking lot. They're bagging groceries and they have a meaningful and productive life. And maybe if we could do more with that, it would be great.
Thank you.
I'd like to just mention, and Bob, you just mentioned it briefly, that the attendee question about why do dedicated accounts continue to be necessary in light of later legislation. Specifically, the ABLE Act allows for savings which do not affect most means-tested benefits up to $100,000 disregarded by SSI program. Additionally, the allowable expenditures from a dedicated account are allowable as qualified disability expenses under ABLE. And finally, the state ABLE program share data under a data exchange program with SSA, and certain account information is visible at SSA. That's a very, very good question. I find sometimes what Congress may not necessarily give, when they're focused on a particular issue, they may not give the global attention to other conflicting policies at that time because they're focusing on the matters at hand. That's not to say that they might not catch up eventually or you know, use this to justify changes later. So, but it's a great point. So thank you for that. It is now 2:30, and this is actually our time to take a brief break of 15 minutes. I want to, before we go, though, again, thank Mary and Jim. Great presentations, great information. Thank you so, so much. I hope you're going to be staying with us for the second panel, because I know we'll have some great discussion then. So if everyone will just enjoy their break, and we'll see you back here at 2:45. Thank you.
Thank you.
That may be our cue to start, but I'll give it one more minute since I have 2:44 on my clock. And I see we have, you know, we're very grateful for the advisory board to have so many people who are here participating in this roundtable. So let me welcome everyone back. Thank you so much. I'm Nancy Altman, a board member, and I'll be moderating this next session of the roundtable. I want to start by thanking Kim and also Mary and Jim for providing such a really helpful overview. In this part, we'll now hear from people who are really on the ground. We're extremely fortunate to have so many important perspectives on this issue. We're going to hear from a parent rep payee. We're going to hear from people in the at SSA who are actually engaged in the administration of this, including former Commissioner Barnhart. And then we also have on the roundtable two lawyers who are assisting people who are navigating this. So let me start. We are grateful to start with Danielle Flint, who's a licensed clinical social worker and a parent representative payee managing a dedicated account on behalf of her child. Danielle, thank you so much for joining us and for your willingness to share your experience.
My pleasure.
We really are so grateful. We are hoping you can describe for us your experience really so, because we've been at this high level and we'd really like to hear how it really works. And then you may talk on what's been difficult, anything you think that you think it would be useful for us to hear. So let me with that, turn it over to you and thank you so much.
You're on mute.
I think you're muted.
I've done that. I've done it before, so I just wanted to make sure that wasn't an issue. Okay, so let me go back. Okay, so good afternoon, all. My name is Danielle Flint. I am a mother of 4 children, 2 of which are currently receiving Social Security benefits. My daughter and my son both qualified for SSI under the sickle cell disease criteria, and both of my children require dedicated accounts to be set up upon approval of benefits. Sickle cell disease is a potential life-threatening inherited blood disorder that comes with many different symptoms. This disease is typically diagnosed at birth. Patients with sickle cell have misshaped red blood cells, which are the cells that transport oxygen. So patients also who have sickle cell have a dysfunctional spleen, and the spleen is the organ that fights invading germs in the body, and it controls the level of blood cells, white, red, and platelets, and it filters the blood and removes any old and damaged red blood cells. This is why patients are prone to infections. Pain crises are also very common where there's blockage due to the misshapen cells, interfering with blood flow and oxygen to important parts of the body. This pain is described by my children as knife-like stabs, which are managed by morphine and stronger narcotics, either through IV or at-home administration. My children have experienced a range of complications from this disease. Both have faced acute chest syndrome, which is a life-threatening pneumonia and one of the leading causes of death in patients with sickle cell disease. Some patients, like my son, will require blood transfusions and treatments during crisis. And during one crisis my son faced, it resulted in the removal of his spleen as it was life-threatening. And he was only 4 years old when that happened. Since there is a 6-year age difference between my 2 children and a 7-year difference in their application date, I'll give you a little background of my daughter's experience for being approved for SSI first. As I mentioned, during infancy, my daughter was hospitalized frequently, and after returning from maternity leave and depleting my sick time, I was terminated from my employer when my daughter was 5 months old. With no income and nowhere to turn, I contacted the social worker for Boston Children's Hospital, and she urged me to apply for Social Security benefits. And in the past, we had discussed this with the chief of hematology, who happened to be my daughter's doctor, and he felt strongly that my daughter qualified and met the criteria under SSI. However, at the time of discussion, my household income would make us ineligible. In September 2008, I applied for benefits on behalf of my daughter. A few months later, we received our first denial stating that my daughter did not meet the criteria for benefits. I called the social worker again for some guidance, and the hematology team encouraged me to appeal, and so I did. 3 months later, after doing so, I received a second denial letter. At that time, I was employed as a family case manager for Head Start and would often refer families to Greater Boston Legal Services for a range of matters. I decided I'd call GBLS and complete an intake. And this is when my daughter became a client of the Children's Disability Project. In January 2010, my case was assigned to Taramati Doucette. We had our first hearing in March 2010, a week shy from my daughter's second birthday. Months later, the appeal was denied. And throughout the years, we faced multiple appeals, including federal court. The case was ultimately remanded and a final hearing took place in October 2015. The following month, a decision was made in favor of my daughter and the benefits would go retroactive from the date of application. In December 2015, a dedicated account was set up for my daughter. It took several months to finalize the correct retroactive amount, but ultimately, my daughter ended up with a large retroactive award that was released in mid-2016. And although a 7-year battle for approval sounds well summarized, there was many times I wanted to give up, and Tara and the project did not allow me to do so. I felt very depleted and defeated. And Tara once turned to me after one of our elevator rides down in one of our hearings and told me, "You worry about being a mom and I'll handle the law stuff." It's something I'll never forget. And I remember a dark time when I stood bedside for my daughter in the ICU, machines beeping all around, and I felt like a complete failure. I was earning minimum wage, lacked higher education, and no cure for this monster that was robbing my daughter of her childhood. All along being told that I could receive some financial support from a program that was designed for a family like mine, but then being told on the other end by the administration that my child isn't that sick. I was stuck in this tug of war with Social Security. Her medical team would provide extensive evidence of eligibility, but every 2 to 3 years, a medical expert sat across Tara and I and minimized her illness, and a denial would follow. And though the 7-year appeal ended in victory, the challenges with Social Security were not over. The dedicated account that was set up for my daughter has been a struggle to access. Fortunately, with the dedication of my daughter's legal representatives and the hematology team, we were able to have funds approved for the purchase of a vehicle that would be used to transport my daughter to and from routine medical appointments and school. The car is also used to get her to and from the hospital in a timely manner, to bring her for medical intervention and avoid being transported without me by ambulance, which has happened in the past when she was a preschooler. Since the approval of the vehicle purchase in 2016, I have yet to successfully receive an approval to use the dedicated account funds to purchase any other qualifying expense for her. My son's benefit story is a little bit different, and he also required an account. His application experience was different, as I mentioned, and his experienced medical challenges were early on, but I decided to hold off applying and wait to see how my daughter's case would play out. When he was 12 months old, I applied since there was enough evidence for an approval, and though his case was more medically complex than my daughter, he was also initially denied benefits. I requested an appeal and he was awarded benefits after the first appeal. Due to the time it took for approval, he required a dedicated account in which eventually funds were released. Through the years, the hematology team has provided numerous supporting letters for purchases on behalf of both children. Each request was met with an additional barrier, requesting more despite how compelling the supporting documents were. There was a time when my washer and dryer stopped working and I requested funds to purchase a new set to keep my daughter's clothes clean and have access to a dryer to heat up blankets when the aches from the pain crisis were unbearable. That was denied. During a time that she had frequent hospitalizations, her doctor suggested getting her an iPad to keep her up with school and access apps that he would recommend. That was denied. Her physician also felt it was imperative that she get enrolled in an extracurricular activity that she enjoyed and embraced her abilities and not focused on her disabilities, and provided social interaction, as this disease is very isolating. That was denied. After my daughter was denied so many qualifying expenses, I stopped pursuing it. By 2017, my son had his funds untouched for 2 years, and at that time he was 4 and very excited to return to preschool in the fall. Unfortunately, 2 months before his first day of school, he became severely ill and was hospitalized and needed to have his spleen removed. An unpredictable recovery with many variables. By the time he was ready to go back to school, it was October, and luckily his school held his placement, but I could no longer afford the tuition after being out of work for 3 months. I assumed with this dedicated account being a smaller amount, it'd be easier to access because it was clearly an educational expense and the only way I could return back to the workforce. I requested his funds this time in person, and though I know the decision cannot be made on the spot, I wanted to provide the representative any additional information to expedite the process. I ended up with an incredibly unprofessional claims representative who simply did not seem to understand the rules governing dedicated accounts. The rules are clear. This expense was for my son's tuition, which falls under education and school. Instead, the representative questioned my integrity and challenged the request amount, stating that this doesn't sound right. Do they know you're receiving public benefits? They should be giving you free or reduced childcare. I explained that this was already a reduced rate and that this preschool was not an ECE program that accepted vouchers. The rep asked proof of this. I went back to the preschool with no tuition in hand to yet ask for another favor, and the director wrote another detailed letter verifying that what I had already stated. During my next conversation following the receipt of the second letter, the rep started to question why I wasn't receiving child support from the absent father. I felt belittled and angry to be treated in this manner and could only wonder how many other vulnerable parents have faced this kind of treatment. What was the most violating was that this employee called my son's school without my permission to ask further questions. My family's privacy was completely violated, and I was humiliated when I had to explain to the school staff why this rep was calling to speak to the director. After this occurred, I contacted GBLS to share my horrific experience, and we ultimately spoke to a supervisor who followed through with the approval to use the funds for my son's tuition after already being enrolled for 6 months. This depleted his account, and then it was closed. This process was almost not worth the humiliation. So fast forward 3 years and COVID hits. I received a call from Tara just checking in. I shared how tight things were financially. I was working from home and balancing the demands of at-home learning for 4 children. My household costs had increased and my hours reduced. I named off a list of needs that I knew were qualifiers to use for my daughter's dedicated account, but I also knew from past experience it would be impossible to access without legal help. Tara provided the manpower I would need. Alarming enough, even with legal help, supporting documents, and in the middle of a global pandemic, all the requests were denied and required more proof. Each request I made was directly in accordance with the guidelines of usage for dedicated accounts and professionally outlined. I'm sure with more time and legal assistance, we can get this approved, but this is unnecessary. So remember back in 2008 when I told you I applied for Social Security on behalf of my daughter. It wasn't the only application I completed. Inspired by my daughter's journey and the professionals that stood by me, I enrolled in college. And in May 2015, 5 months prior to our final hearing, I graduated with my master's degree in social work and obtained my LCSW. I am currently a candidate for my independent license pending an exam, and I currently work for early intervention and as a childhood social worker and help families like mine. So here's my advice on how to improve the use of dedicated accounts. Eliminate them. They're not necessary. Parents know what their children need and how to best support them. As I tell my parents I work with, you are the expert in your child's life. So much is left in the discretion of the representative, and this is a problem. Claim representatives who don't understand the rules or have strong opinions about who should receive SSI create huge obstacles and barriers to accessing the dedicated account funds. In my case, the administration failed my child from the start, and the lack of knowledge caused the need for the dedicated accounts in the first place. Why punish a family twice? It would be ideal to be able to access these funds without any barriers or hurdles, especially during this pandemic. For example, during this pandemic, I've had to buy additional cleaning products, hand sanitizer, laundry detergent, and masks. The cost of food and utilities have increased, which are all basic needs that exceed my wages and the supplement income I receive from SSI for my kids. As I look at my accounts trying to figure out how to pay the next bill, there's a large amount of money that I cannot access. Yes, I can apply for government help, but why take from another family that can use it when I have an account designated for these expenses? During this time, SSA should just waive the rules for accessing any dedicated account funds so low-income families like mine can meet the needs of their disabled children without hesitation or punishment. This COVID world is not new to a family like mine. During this pandemic, the world has faced job loss, struggles to meet basic needs, risk of homelessness, isolation, and depression. I repeat, this is not new to a family with a child who is disabled. However, there's no current stigma around job loss, struggles, or accessing public benefits like unemployment. So please keep in mind when dealing with a family of a disabled child, we live in a constant pandemic, but typically the world is just not that understanding. Thank you for your time.
Wow. Danielle, that was, you're bringing me to tears. That was very, very powerful. And I now, fortunately, most of the people who work at the Social Security Administration are very dedicated and are also boxed in by these rules. I'm sorry you had that experience, but let's now hear from one of those dedicated employees. David Lescarini is president of the National Council of Social Security Management Associations. He's going to start us off by providing on the ground, as I say, concrete look at how the field, at the issue of dedicated accounts from the perspective of the field office that are getting these requests. And then after his remarks, we will open it up more generally. So David, the floor is yours. David, are you muted or?
I was muted. Can you hear me now, Nancy?
We can hear you perfectly. Great.
Oh, okay. Thank you. Thank you. Thank you for letting me be here today. And I just want to express my sympathy for what the previous speaker had to go to. I'm sorry you had that bad of experience that you had with your local office. And I hope that they have resolved the issues. I'm going to try today to give a perspective of from a workload perspective of what happens in a field office. Most dedicated account situations occur when a child is first approved for disability benefits, though some do occur while processing redeterminations, medical cessation appeals that do not have benefit continuation, or verification of household income that results in an underpayment to the child. In all of these instances, the underpayment, which is defined as a past due benefit, must be paid into a dedicated account if the total underpayment amount exceeds 6 times the federal benefit rate, or FBR. This year, the FBR is $783, and in 2021, it will be $794. At this point, the representative payee is required to establish a dedicated account and provide the field office the name and address of the financial institution, the routing and account number, the account title, the type of account, and the amount of money deposited into the account, if any. This account cannot be the same account used for the monthly benefit. The field office must then have the payee sign and date an SSA 552 dedicated account use of funds statement, which must then be uploaded to the electronic folder. Because the dedicated account information is not captured within the SSI program itself, the information provided by the payee must be loaded in the remarks field, and a report of contact must be made concerning the information. At that point, the technician must use the automated one-time payment process, AOTP, to pay funds to the dedicated account. This is a manual process that involves one employee loading the payment information for each month and a second employee of equal or greater pay grade reviewing and approving the input. Because any underpayment over 3 times the FBR must be paid in installments 6 months apart, but in no more than 3 installments, dedicated account benefits are subject to this provision. When an underpayment is subject to installments, the system uses what we call diaries to alert field office technicians when subsequent installments are needed. In addition, field office managers can maintain a manual list of these cases as an additional control in case the system should not operate as intended and set the diaries correctly. Once a dedicated account is established and payments are made to the account, the payee is limited as to what the funds can be used for. And I know it's been mentioned several times, but I'd like to cover them again. They can be used for medical treatment, education, and job skills training. In addition, as it relates to the child's impairment, the money can be used for personal needs assistance, special equipment, housing modification, therapy, rehabilitation, or other items and services that SSA determines appropriate. In addition, there is the emergency exception that I mentioned earlier in the first hour. If the payee wants to spend money from the dedicated account and they are unsure if it falls into one of the allowable categories, or if they have another need that is not explicitly listed as an allowable expense, then they are supposed to contact the field office and ask for permission prior to spending the money. Because each expenditure request is unique, FO staff must consider all requests carefully and ensure that the payee has the opportunity to explain the connection between the expenditure and the child's impairment. FO staff must use their best judgment to decide on a case-by-case basis whether the expenditure relates to, results from, or would improve the child's condition. They must take the following steps during the determination process. They have to once again manually put remarks or report of contact, remind the payee of record-keeping responsibilities and the annual accounting, and provide the payee with a notice, whether it was approved or not, plus appeal rights. Note that this notice is a manual notice. The system cannot automate such notices. Our policy manual does have many examples that employees can refer to as to what can and cannot be approved, but it is not an exhaustive list, and discretion lies with the deciding employee. As mentioned previously, we require a payee to keep records and receipts of all deposits to and expenditures from the dedicated account. And in addition, the payee must submit an annual accounting report, a Form 6233, Representative Payee Report of Benefits and Dedicated Account, for the use of benefits and the activity of funds in the dedicated account. This is a 3-page form with 5 pages of instructions on how to complete the form. Pages 1 and 2 are for accounting for the monthly benefits if required, and page 3 is for accounting for the dedicated account benefits. Question 7 on the form asks the following: did you take any money out of the dedicated account during the report period? And were these purchases for medical treatment or education or job skills training? If the payee answers no to the second question there in Part B, then the field office will have to determine if the expenditures were allowable. If the payee asked for permission prior to spending the money, then documentation should be in the electronic record. If prior permission was not asked, field office staff have to determine after the fact if the expenditures were allowable. If the employee determines that the expenditure was not allowable, then the employee must conduct an investigation to determine if misapplication or misuse applies. And these are two different concepts. The use of funds from a dedicated account for an expense not authorized is considered a misapplication of funds when the expenditure is done knowingly and when the payee knew that the expense was unauthorized, but the expenditure was used for the child. In that case, the payee is responsible for returning that money to the dedicated account. Misuse applies when a representative payee receives payment for the use and benefit of another person and converts such payment to a use other than for the use and benefit of the other person, in this case the child. So there's a difference there. This is a brief overview of the dedicated account workload process in the field. I'd like to end with some issues that often arise, as well as the impact of the pandemic on the process. First, many financial institutions are not familiar with the dedicated account concept, which can lead to difficulties for payees in establishing such accounts. It is not uncommon for banks to suggest that one account is good for both the back pay and the monthly benefits, which is true for individuals who do not need a dedicated account. This leads to banks contacting the field office for clarification or recontact by the payee on the issue. Some individuals have difficulties in getting bank accounts because of past issues with local banks, and direct express accounts are not an acceptable type of account. This is particularly noticeable in rural communities that are underserved in regards to the availability of financial institutions. The dedicated account process is an added burden on the payee and takes away their discretion in using the funds for emergency situations. For field offices, it is a labor-intensive process in developing requests for expenditures and for accounting for such benefits. Also, even when a child turns age 18, if they are still entitled to SSI benefits, the dedicated account stays in place, and even if they are now their own payee, they must abide by the dedicated account rules. Lastly, the pandemic has made it more difficult to administer the dedicated account program, due to the need for all these forms. Expenditure, such as expenditure requests, the Form 552 at the beginning that has to be signed. So the pandemic has made it more difficult because we're having to use the mail for pretty much everything, and individuals may not have access to fax machines, though we could use that. That ends my comments, and I would be happy to answer any questions.
Well, thank you so much. Let me just ask you one question, and then I'm going to ask questions of the panelists who haven't spoken yet, and then we're going to really open it up for sort of a round robin. And as Kim said at the beginning, we're very fortunate to be joined by two other managers of field offices, two other colleagues of David, so Greg and Rachel, so all of you should feel free to jump in. Can you talk a little bit about the pre-COVID and post-COVID, and or not, I wish it were post-COVID, pre-COVID and COVID period, in the ability to review these accounts, and also the former Commissioner Joanne Barnhart in the first panel also talked about that there might be some fair amount of discretion on the part of the commissioner, even without legislation, to change things. From your perspective, as the ones who really have to implement this policy, what kinds of changes, if you ruled the world, what would you recommend? So that's a lot, but if I can just get your initial thoughts, that would be great.
Okay, I'll try my best. I'll say before the pandemic, one of the things, and this is just anecdotally from my experience and as field office manager, a lot of times when someone has a request for an expenditure out of the dedicated account, it's an immediate need. They're going to come into the office, they're going to discuss it with the technician, and you can oftentimes make a decision at that point and say, well, I think we can approve this, just give me the receipts, give me an estimate of how much it's going to be, and you can go ahead and release the money. So it can be a pretty quick decision. Right now we're in a situation where all of this is having to be done by mail for the most part, unless somebody has access to a fax machine. So you're talking about someone having to call our office, talk with a customer service rep who answers the phones. They're going to have to hand that case off to a claims specialist who can actually approve the expenditure, but they're going to have something in writing before they can approve the expenditure. So it has prolonged the process. As far as what we would like to see, I can say that NICSMA as an organization has advocated for the elimination of the dedicated account provisions. We advocated for eliminating the accounting for parents that are payee for children and for spouses, and that was nice to see that happen, but we would also advocate and have advocated for the elimination of the dedicated accounts provisions themselves.
Thank you. And let me now bring in Joanne, if it's safe for you. I know I won't want you to, but to because that's a really I think David presented a sort of good jumping off point that that there's and I should say, I hope, Joanne, you don't mind me revealing this, that Joanne and I go way back because we actually worked on the Hill together in the 70s. And, so we all, and Kim's worked there for many years, so we all know how hard it is to get legislation through Congress. But this is one where you've got both Democratic and Republican administrations that have advocated for eliminating dedicated accounts. Do you have any sense, is there, from your years of testifying on this and working on this, whether there's a hang up with it, or because you'd think it could just be slipped into something, or it's too low priority? And anyway, and then please, any other comment you want to make before I turn on to the other panelists who have not yet spoken. And Joanne, I think you're on mute if you heard that question. can anyone, is there a way to tell if Joanne's muted or?
It appears that she is muted.
Can you unmute her, or if not, we'll move.
The host could unmute her if she'll allow us to unmute her.
Well, you know what? Well, the two of you figure that out. Why don't I move on? Because we're also, as I say, very fortunate to have two attorneys who work on these issues, Tara Doucette and Linda Landry. And I assume, Tara, that was you that Danielle was referring to, and I love that advice. To you know, that you'd worry about the legaling. So let me ask both of you if there, again, the same kind of question, what you've seen on the ground, sort of pre-COVID and COVID, and any other kind of comments you want to make about this issue of dedicated accounts that you think it's important for all of us to know.
First of all, thank you all for having the Children's Disability Project, for having me participate in this roundtable. This is a dream come true for me, so that I get to talk about this issue. In my agency, Greater Boston Legal Services, I am known as the person who's pushing that rock up a hill. And I'm so glad to hear so many people say it should be eliminated. Professor Mary O'Connell was my professor at Northeastern University School of Law. In fact, we had named a couple of fellows, a fellowship after her, and we've had a couple of fellows. They worked on the article with Mary. Danielle's experience, I just want to make a couple of comments. Danielle Flynn's experience, and thank you for your kind comments, Danielle, about the representative, about the claims representative that wasn't so. There are some claims representatives who are like that, but there are many, many very kind and good claims representatives who want to help. So, because I know we have the next people there, so staff there, so I want you to know that, and we are work closely with our local field offices, and we do know it's hard work, and we do know that they are so understaffed. We get that. You'd walk into an office and it would be jam-packed, and you'd go up to the window and there would be just it was open. We totally understand that. And Linda will speak later on to tell you, because Linda hosts our national, our wide coalition, so she gets all the problems that we encounter. For a couple of things, pre-COVID, while, you know, I appreciate the report of the process, what our experience on the ground, it's very, very difficult. Why does it take a lawyer to go before the Social Security Administration to get somebody a computer, or for tuition, or a medical expense paid? That shouldn't happen. And that's kind of a consistent problem. And we see it. And like Danielle mentioned, after we got her the first item, which we advocated for, she just kind of went away. And I called her back because of COVID. And here she was like, I have all of these expenses and I can't use this money. I mean, to washer and dry a thing. She should have been allowed to use her money, right? Plain and easy. And I've got to back up a little bit about the Children's Disability Project. I know that Emma had gone to our site, you know, the Social Security Advisory Board staff went to our site, the Children's Disability Project, and you looked at our materials there, and that's how we got involved. We got invited. We decided to create the Saving and Spending Workbook to guide families, because there was nothing out there really in language and in a kind of developed in a way that people could really understand how do you navigate this dedicated account? What are the do's and don'ts? I was looking at it. I printed out some of what we did, and I have to say this: like, what is a dedicated account? The do's and don'ts of a dedicated account. Keeping back benefits separate. This is what you have to do. Can I put my funds in the dedicated account? How to get permission for a special purchase. And this is what you do. You need to know the cost. You need to get a doctor's letter, or it's all in here. How to keep track of your spending. So we decided to do that. And we thought that would have a big impact. And this is pre-COVID, post-COVID, it's the same issue for us. It's not being covered. One quick thing. Because I heard this misapplication term come up so often in the conversations, and we do know about the difference with misuse and misapplication. I have never seen a misuse allegation. I have seen one misapplication allegation, and I took it all the way up to before the administrative law judge, and because of a court order, the monies were released. And I want to just briefly talk about the story. I called the client Deidre, and I'll do it very quickly. So this story is about Deidre, a 22-year-old girl a young woman who received SSI as a child, but later when she graduated high school, SSA would not release dedicated accounts for college tuition. Deidre's impairments was depression, atopic dermatitis, psoriasis, obesity, and she has a learning disability. In March 2008, Brenda, Deidre's mother, applied for SSI. The application was denied twice, and then in 2010, she came to CDP for legal help. She was 13 years old when I represented her, and we won. And then the mom went away. Then it was, Deidre graduated high school. And when her claim was finally, I should step back and say when her claim was processed, she was owed 31 months of retroactive benefits that was slated to go to a dedicated account. So Brenda was Deidre's representative pay. And you take your clients as you get them. Brenda has her own impairments. She has disabilities of her own, and she had a long work history despite her disabilities, despite her impairments, until she had a serious injury and she could no longer work. So she was on SSDI. Also had a learning disability, the mom. So and she's able to navigate her child's account. So then 6 years later in 2016, because I'm not thinking about Deidre and Brenda anymore, I'm moving on to my other cases. I'm representing Danielle now, right? So Brenda contacted CDP because in that 6-year span, only one installment was paid, and it was for $2,113.20. And guess what? She used it because she followed it. She thought she was following the rules. She was spending it on her child. And then Social Security said, hey, we can't put any more money in that because you misapplied that. We're hitting you with misapplication, and we're not going to pay any more installments. And that was that. So by that point, Deidre wanted to go to college. She wanted to go to Quincy College. She wanted to enroll in class. There's no money, so she went to Social Security for tuition, for money to pay tuition. And that's how she found out that they had this misapplication. I'm not going to go into all of these details, but this case involved this mom who had a very limited income paying back to Social Security $50 because as the Social Security reps here know that if you are charged with a misapplication, there's a plan to pay it back. And she thought, I am paying back $50. It is going back to my daughter's dedicated account. I will do better next time. I will follow exactly what they say. She didn't realize that $50 that she was paying back, that she could barely afford, was going back to the US Treasury. It was gone forever. She didn't know that. She cried when I explained that to her. She had paid that until she couldn't pay it anymore. Well, the first visit to Social Security, this is where I have to say I met a very nice, brilliant claims rep who knew the rules, and she released part of money, and it was the first installment, and we were able to pay tuition and books. She happened to, she got pregnant, and she went on. This is real life. I'm telling you on the ground. It's our turn to tell on the ground. So I need to tell on the ground. It is my life. She got pregnant. She went on maternity leave. Guess what? It was time for Deidre to pay for the next part of her tuition. We went back to Social Security. That rep said, no, I still see that misapplication. You're not getting any more money. I'm embellishing, okay, just for to make it not so dry. And so, no, you're not getting any money. You're denied. No. So what happened is that I took this to the law judge, and here's what the judge wrote. He was like overwhelmingly in support of, believe this claimant because he saw all of the receipts and all of that. And he wrote an expedited decision. And Mary, I also sent him your article after the fact, and because I was so thrilled with his decision. He wrote, I find that Brenda's mental and educational limitations support her testimony that she did not knowingly violate the rules regarding the appropriate expenditure of funds from this account. Furthermore, Brenda's statements indicating that she always attempted to comply with SSA rules and regulations are supported by the fact that she consistently provided receipts for her expenditures associated with this account, including receipts dating back to 2011 and 2012. Remember, we're in 2018 when we're having this hearing. Brenda may not have fully comprehended the minutia of every portion of the regulatory framework of dedicated accounts, but the record certainly indicates that she consistently made good faith efforts to spend funds on this account on her daughter's behalf. The record as a whole supports the conclusion that she did not misapply the claimant's dedicated account funds because she spent the funds on allowable expenses, including educational and impairment-related expenses. And this judge actually put the hair treatments that the mom used because of the psoriasis, and he actually put the foods that she was purchasing, the special foods to help control her obesity. And he put that in the decision, and we got an expedited decision in this case. So I just had to share that. I think having someone blocked from their education, a young woman with a disability who started this process at age 13, and then, as others mentioned, she became her own payee when she became an adult. She became her own representative payee, and still that money was on lockdown. She could not access it. And how sad for her. She was blocked from her education. I am pleased to say that we started this journey a while ago. In 2019, the last payment was made, and she's all done with her dedicated account. So that's my story.
Oh, Tara, that was very, again, we wanted to hear on the ground, and we definitely are. And I see that Joanne was unmuted and now is muted again, but I don't know, Emma, if you can unmute her, Joanne, because we'd like to bring you into this conversation as well.
Asked her to unmute, and I believe she has to press *6.
I think she
Can you hear me now?
We can, Joanne.
Can you hear me now?
Yeah, we can.
Oh, great. I could hear you before, Nancy. Thank you so much for trying to bring me in earlier, but I could not unmute. Okay, so I want to thank all three presenters for their comments. Extremely helpful and really wonderfully different perspectives and insights provided. I did want to ask some administrative type questions of David, because when we talk about whether or not dedicated accounts even make sense, fiscally speaking, it's David, correct?
Yes.
Yeah.
Yes. Okay, so my question, I have a couple of questions. If I am a parent who is calling in to inquire about expenditures or to get approval for expenditures on a dedicated account, am I calling the 800 number or am I calling a specific person?
Well, you could be calling either, but it's really, when someone does an update on somebody's record, the perks, when somebody gets approved or redetermination, the technician is supposed to inform the individual, here's my name, here's the phone number, here's the extension, and they should be telling them, contact me if you have a question concerning, expenditures for the dedicated account. Does that always happen?
The reason I ask that is because I know the tremendous strain the 800 number is under and the waiting times and so forth. And I also know from my own experience visiting district offices and talking with claims reps that they're often totally backed up in terms of voicemails too. So the first thing is, my question would related to specifically how timely a response does the parent or the person who is responsible for administering the dedicated account, how timely can they expect action? I don't expect you to answer that. I just raise that as more of a general concern, given the agency workloads and the claims rep workloads and backlog of voicemails, typically speaking. The second question is this.
Joanne, let me open it up because we have two others who are managers too, if any of them, because I think that is a really important question about the timeliness that's part of the problem with the need for approval. So do either of the others, Rachel or Greg, have anything you want to add on that before Joanne goes to her next question?
Nancy, this is David. Greg had to drop off. He had another engagement, and Rachel. Yeah, Rachel's actually our Washington rep, so she's not a field office manager.
Okay, thank you for that clarification. Joanne, back to you.
Okay, so my second question is this. The people who handle the issue of the dedicated accounts, is it a specified workforce within the district office, or is it just sort of, if you happen to be the claims rep who was assigned that particular beneficiary, that you handle that? Do you understand what I'm saying, David?
Right. I would say in general, it's probably going to be the same claims specialist that handled the original dedicated account. Though I've worked primarily in rural offices, and that's been my experience. I can't really speak for a large metropolitan office with 50 or 60 claims specialists. They may have somebody dedicated. That I'm not sure. I can't speak to that.
Yeah. So the point I'm raising there is, if it's handled by the claims reps, generally speaking, and I have tremendous respect for the claims reps. I've seen the POMs, believe me, tremendous respect and seen them in action. But it is a very specialized area that requires discretion and judgment and a certain amount of knowledge. And so I do think that is something that contributes to perhaps misapplication of the way that the rules and the regulations read and result in the situation as noted by our parent, who's unfortunately, I apologize, but I couldn't hear your name with the road noise. But your story was incredibly compelling, and I'm very sorry you had to go through it too. And I just want to reiterate what Nancy said, which is, in my experience, 99.9% of the Social Security employees are incredibly dedicated and want to do the same thing, the right thing. And I'm really sorry that you got one who, for whatever reason, wasn't able to live up to that. So Nancy, I'll turn it over and let someone else go. I'm just trying to help build a case from an administrative side for why perhaps the dedicated accounts end up being don't make financial sense, from the standpoint of budgetary concerns, which were one of the things that brought them into existence to begin with. So that's it for me.
No, that was very, very helpful. And we are really so fortunate to have so much expertise and so much firsthand experience on this issue. And we're really talking in two levels. One is that, what we could do if we could have legislative change, but also are there things we can do short of legislation or before legislation to improve? So, as I say, even if, Danielle, you had a great claims rep, it still would have had problems. I mean, it's money that someone else is you have to report to. So with that, let me start with people on the panel who may have comments or questions for each other or have some conversation among yourselves. And then we'll go to board members for questions and conclude with questions of others who are, and again, thank you. I can see we've got lots and lots of participants, so thank you. And let me repeat that if you have questions, please either, I guess, put them in the chat, right, Emma, or they can email the events at ssab.gov. So with that, so if you're thinking of questions, send them on. Emma's we'll catch them as soon as they come in. But let me start, Linda, if you've want to add something, and people from the morning panel, anyone who wants to either make a comment, ask a question to somebody else, make a comment to someone else.
I'd like to make a couple of points, Nancy, if I may. Thank you.
Absolutely.
And thank you for putting, whoever put this panel together. It's been a great experience, and it's so needed. And I wanted to thank Commissioner Barnhart for her remarks as well. You know, even before COVID, local offices have been understaffed. And I don't think the dedicated account workload has been a priority workload. Claims reps do a difficult job. They do what they handle the priorities that they're supposed to be handling. The dedicated accounts are really, relatively speaking, a small portion of the job, but a very important part of the job, which, as we've heard, requires a lot of knowledge and discretion. And I think that's possibly why Tara and I and a lot of other advocates and Danielle, sorry, Danielle, I wanted to rename you Kim. You remind me of a Kim I used to know. Anyway, have seen such, you know, trouble getting perfectly approvable expenses approved. And by the way, when I speak to parent payees who are setting up a dedicated account, I have yet to hear one who understood the difference between how they can manage the pay responsibilities for the monthly expenses versus the dedicated account. You know, what does it mean, something that benefits your child? You know, what does education expense mean? People have their own ideas about this, and they often don't have the time to talk to somebody long enough to get a full explanation. And also, I also tell them, you know, even if you think it's perfectly allowable, it's always best to get permission ahead of time, because the next person who looks at it might have a different idea. And if you have it in writing that it's allowed, you're good for the next time it's looked at, because it's, you know, annually these expenses get reviewed. So what do we really think should happen? I mean, I think that in the COVID emergency, the short staffing and all the problems you've heard are really magnified. You know, people need the money to have a healthy life for their children, and they really can't get access now. It's even worse, even though they have a greater need for the funds. And we would like to see some emergency proclamation to suspend the use of the dedicated account rules during this emergency and not penalize folks for using benefits as long as they benefited their children. At the very least, however, what we'd like to see is that SSA train claims reps to use maximum flexibility with the existing dedicated account provisions, what things can be spent on, and also work to add more explanation, more examples that are more inclusive. And you'll see some of those in the materials that Tara has provided, along with some of the other case examples. And by the way, I wanted to ask if someone could put in the chat where you find those materials. They're a little hard to find. I think they're available as resources to people who are watching.
Yes, I will send the link again.
Thank you, Emma. Thank you.
Yeah.
I appreciate that. So, and you'll see there are a number of in those materials, the materials that Tara sent in, there are a number of ideas for expanding examples so that claims reps feel comfortable saying yes, perhaps sooner. You know, one of them is an education expense. All children need computers these days to go to school, especially children who are now unable to go to school. Some school systems have supplied computers to children, but not all of them have. And so children who special needs who are at home and don't have access to a computer are really missing out. And, you know, frankly, I think all kids need to succeed in school to have a computer to do research, especially now with the libraries being closed and everything. So there are a number of examples there that we would like to see available to families during COVID, but also after. And that's a change in the POMS, which doesn't really require a huge lift, I think. There is that other more discretionary provision that is in the statute that says any other item or service the commissioner determines to be appropriate, provided that such expense is related to the impairment of the child. So there is a huge other category that I think could be fleshed out more so that claims reps would be comfortable, allowing more different kinds of expenses more quickly. I think that's probably where the emergency exclusion came from. The emergency exemption for shelter and food items, if the child is likely to become homeless or malnourished, is not in the statute. So that must have been something that came in under this other discretionary function. In addition, the statute gives the commissioner great discretion on systems of accountability for dedicated accounts. It just says the commissioner shall establish a system for accountability and monitoring. It doesn't say what it has to be. Again, we'd rather see the dedicated account go, but understand that will take some time and that there are other mitigating measures that can be taken. In addition, I think, I don't think dedicated accounts were ever needed, except perhaps politically. I think we got them because there was a misunderstanding of the SSI program. There's a misunderstanding about mental health. I think people thought that SSI for kids should be for kids with the kind of disabilities you can see. I remember one of those programs from 1995 watching, there was a picture of a child riding a bicycle, and the child was alleged to be receiving SSI, and the context was, how can a child who can ride a bicycle be disabled? And so I think this is where a lot of the essentially discrimination comes from. And I think, at the time the dedicated account was established, installment payments were established, and the installment payment then allowed for an initial payment of 12 times the maximum benefit payable, and then another one in that same amount, and then a third for the rest of it. Now the installment payment requirement since 2005 is only allowing 3 times the maximum benefit payable, which is, a lot less money. So there's a lot less need for a dedicated account. I actually don't like installment payments. I think they're also expensive for Social Security to manage. If you need more money than what's in the first installment, you have to come forward and make a hardship agreement, hardship proof, and show that you need the money for some important purpose, which is, again, more work for claims reps. But it is perhaps the lesser of two evils if we have to have either dedicated accounts or installment payments. I'm not sure why we need both. And there are also ABLE accounts now available to families. It would be great if families had the option of, not putting money in a dedicated account, but putting it in an ABLE account that can be more broadly used. And they can also use ABLE accounts to teach a child with a disability how to manage their own money much more easily with an ABLE account. So I think I've rattled on long enough, but hope
that was very helpful, and there was a lot in that.
I know.
That was very useful. Let me first say I thank you for thanking us for having this, and the thanks really go. We have a really fantastic staff, as you can tell, and they Claire and Diane and Emma and all the rest of the staff have been terrific. And I think you raised an important point too about what are sometimes called invisible disabilities, that
yes.
the American people really have to be educated about it. And you also had a lot of interesting thoughts about discretion and maybe being able to use an ABLE account. And although I think I'm not sure the law can be stretched quite that far, but let me open it up to other everyone else who's on the panel, if you have questions for each other, comments to each other, anything you sound at this point that you're all agreeing. Are there areas of disagreement? David, I'd be curious if you had thoughts about, and Joanne as well, if you're able to, as you're able to unmute, some of the suggestions Linda had and so forth. So there's a roundtable. Let me open it up to anyone who wants to speak. Just jump in, and then we'll start turning to questions.
May I go just very briefly?
Absolutely.
Before coming, thank you. Before coming to the meeting, I just did a quick run because, I'm at home in my dining room, my little spot during this Zoom. Did a quick run on the numbers that we had since we started the project. We had the number of children we represented. We represented well over 700 kids. And I tried to do a little breakdown on the percentages. And I found that 75% of the children I represented, or we represented in CDP, were children of color. And there was like an even split between Blacks and Hispanics. And I say that because this is COVID-19. And I need to make this comment because we can't look at Social Security in isolation. We have to look at what's happening around us and who is suffering. And every time I look in the media or I open a newspaper, it's all about Black and brown people and what's happening to people of color. The pandemic has had devastating effects on communities of color. And we know it's because of the inequities, economic inequities, health inequities, education inequities, and I'll add another one, internet and Wi-Fi inequities, the broadband inequities. I read something about that recently. So all of that's affecting the people I serve, the poorest of the poor and the most vulnerable, children with disabilities. And you heard from Danielle and her struggles. She couldn't get that washer and dryer in, all the hand sanitizer and the things that she wants to buy, that she's buying that's eating up her budget. So immediately what's needed during this pandemic is for Social Security to, I want to say, lift the rules, suspend the rules. When we wrote to the Massachusetts congressional delegation, we actually were saying, can we have a moratorium, just like basically the housing moratorium, something so that people with who representative pays can actually say what they want, or use the money and provide the receipts and say, here are the receipts, this is what I used it for, and this is how I used it to help my child, and get it approved. And I felt like those numbers were very important for me to tell you about, because of our location, where my office is located. We serve the greater Boston area, my Dorchester, Roxbury, Chelsea, and every time I open a paper, these are the communities that are hit the hardest. And I want to help the clients I serve. And I'll say one last thing. When I took on the class action lawsuit against BTA, I never thought we could do this massive case. I'll tell you something. We set about to change the culture of the MBTA. And I think we can change the culture of the Social Security Administration. I'll tell you why I say that. So, Linda, you talked about the kids with non-apparent disabilities. I think changing the culture, what I mean is to be more receptive of families with children with disabilities, and to trust that, as Danielle said, a mom knows what's best for her child. Don't come and say negative because you know all the stories from the media in the past. Don't have that in your background. Move forward. Think about families as moms. These moms know what to get for their family, for their kids. Trust the mom. So it's kind of changing that culture a little bit is something I would love to see. That's my comment.
Well, and thank you for bringing in that perspective. I mean, we are at a moment in our nation's history where we're really talking about systemic racism and racial justice. And some of what Mary was talking about with the attacks on welfare have those undercurrents as well. So let me, at this point, open it up to board members if, and I've got a few questions as well, but Kim or Jagdish or Bob, do you feel free to jump in and either make comments or raise questions or pose questions either to the whole group or to individuals. Let me bring everyone else into this conversation because I think this is an extremely educational conversation for all of us. And the idea is to get different, not necessarily points of view, but different angles on this because and perspectives that way. So Kim, go ahead.
I'm happy to start out at least. I have two questions. One is for David. And David, I'm wondering, I think I'm right about this, that SSA put out, I don't know if it was an emergency message or instructions to the field, kind of reminding them of the flexibility that they have to allow distributions from dedicated accounts that meet the overall criteria. A, do you recall when that message went out, and have you seen, a little bit of a different approach by the field to go ahead and respond to those requests?
So off the top of my head, I do not remember when that came out.
Okay.
But as far as have I seen a change, in my experience, there's always been a lot of flexibility in approving expenditures from the account. So I was actually pretty shocked when I heard the experience that the prior speaker went through.
Mm-hmm. Okay.
And Kim, David, if I can follow up, how about the fact that the field offices now have to be closed and you're all working remotely for, obviously for safety? Has that had an impact?
Yes. Now that would have an impact because of the fact that, I think one of the questions earlier was the timeliness that was asked, and obviously it's a lot more timely when you're open to the public and the person can come in, see somebody that day, and at least have a good idea as to whether or not their expenditure is going to be approved. Whereas right now, when you're having to conduct everything by mail, I would assume that there are going to be longer delays in getting approval than there were in the past.
And Tara and Linda, you are on the ground with that. Are you seeing that as well, that it's harder because the offices are closed, or is it not? Do you see the difference or no?
I think the message came out in June. I can answer that question. And we were glad to see the message. Well, we didn't see it. It was not made public, but we were told what was in it. And but I think it really wasn't enough. It still leaves too many questions about what's approvable or not. What does maximum flexibility mean? It means something to everybody else. And it doesn't mean to deviate from the coverable expenses listed in the POMs. It just means to be, I think, flexible with them, or at least that seems like a likely interpretation. Tara, have you seen any difference in responsiveness when you've had to contact local offices about the dedicated account spending?
We just,
since June?
well, since June, well, Danielle, we put in for the couple of things for Danielle in June, and we did, not in June actually, we did this in August, and actually they did respond back and say they needed more information. And I don't know if it's because we were using the e-faxes and everybody's at home, but that one we did get. And the other quick, do I call it quick? The client who received the notice to quit, he was about to be evicted. He came in March. That's one of our office shut down, but I took his file home. And but that took regional office's help. So, and I was able to, by August, that was resolved from March to August. He was allowed to use that bit of a dedicated account fund, but regional helped with that. you know, and I don't know if he could, responsiveness was to me because I'm pushing it. If you're asking Danielle responsiveness to her, maybe that's a different story. Responsiveness to me means you have a lawyer calling regional, calling everybody, calling the manager, emailing, right? So that's the difference. So that speaks.
Well, and I think that's an important point too, because not everyone represents people, whether it's child disability eligibility or whether it is, not all lawyers do this. In fact, most I think do not. And so there's very little representation to people, either on SSI claims for children generally, or for on dedicated accounts very specifically. You know, I know that Tara does it, and a few others do at the legal services programs in Massachusetts. I know Community Legal Aid in Philadelphia does, and there are probably others, but the point is, I don't think it's widespread available representation.
And people often don't know that they should seek representation.
That's true, true.
And I see Bob as, I take it you're unmuted and you're visible, so I assume that means you have a comment or a question.
Very perceptive of you, Nancy. First of all, I just want to say that this is an absolutely fantastic discussion, and the amount of expertise and experience that our staff have brought forward and all of you brought forward are stunning, really. It's great. I'm going to come at a slightly different angle, because one of the things that our advisory board has also been looking at is the representative payee system and how that's administered by Social Security. And one of the questions that's come up there is whether Social Security really is the best place to be making decisions about individuals who have in their lives, in terms of you know, what their mental capacity is, their cognitive capacity is, what are the circumstances in life, who are the people who care about them, how are they doing in terms of using their money wisely or legally. And one of the questions that's come up there is whether Social Security, the federal agency, is really the best place to staff to make those sorts of calls in people's lives, or whether that would be something that would be better done locally, perhaps through at the state level or the locality level. And so I'm completely convinced that the present system that we have here is not humane or effective. But if it were to remain in place, could it be done better by someone else rather than Social Security claim representative?
Anyone should feel free to jump in if you have a thought or a response.
I was going to say something to Bob, but that assumes who's holding the money, because right now it's Social Security that has the strings to hold the money. I mean, I understand the money's in a bank somewhere, but if you're envisioning this more local group of people, maybe more oriented towards understanding disability, because there's so much that a claims rep in Social Security has to deal with. Are you going to move the money somewhere, or release Social Security's obligations for seeing that the money only goes according to the statutory categories?
Well, in the representative payee area, one of the things we've talked about is the fact that in actually sort of many of the same types of administrative hiccups that we hear about, we hear about over there as well, in terms of the claim rep works for an agency that's very, very effective in moving an enormous amount of money every year and getting it to the right place. But in terms of really assessing individual needs and capabilities and effectiveness, that's a bit removed. So obviously, if there was some other entity that was performing this task, there would have to be set up a contractual or system in which certain responsibilities were delegated and so forth. So I don't know about the particulars and how it would work here, and I'm not really suggesting that we should continue the system the way we have it now, but I do wonder because I hear echoes from the other work that we've done as to whether this federal agency that's very, very effective in doing one thing when they're given the task of doing something else that requires much more individual contact and assessment, if that's really their strong suit and if there might be a better way to do it.
Well, and I think actually this exchange really brings up another issue and something I'd like to ask a question about, that part of what is going on, there's a lot of pressure from lots of different places for the Social Security Administration. And one, of course, is Congress. And as Mary said, they see stories in the paper, or they hear from constituents that there's all this kind of fraud going on. And they say, hey, Social Security Administration, what are you doing? And if it is an interesting question, if they were just really just paying out the money to the address and someone else was in charge of the rep payee, whether Congress would shift its focus or still bring its guns towards the administration. So it's complicated. And that really, another piece of this we haven't talked about, because we were very focused on, and as I love Mary's comment that, in the law you focus on something very narrow and you don't get invited to all the parties, but it's you become the world's expert on it. So that we appreciate the work you've done on it. David, and this is really a question for Linda, Danielle, and not Dan, or Danielle, you're free to jump in, but it's really a question for Tara and Linda and David, and that is, how high a priority is it in your work world? I mean, how many of these, how much of, in David, in your office is this, and it really adds to Joanne's, is that it's really anybody who does it, because there isn't just enough of it for someone to specialize in it. And the same thing with Linda and Tara. Linda made the point that there aren't that many who represent in this issue area, but is that because there just isn't that much work there, people coming in, or another reason? So David, why don't we start with you and give us a feel for how often these claims come in, when they come in, how much time is expended, whether it's one claims rep or whether it sometimes has to be looked at by a supervisor, sort of someone, Danielle walks in the door and says, I need the money for tuition for my child. What would be the next? And maybe that's too easy a one, but one that's more, that's maybe grayer in the area. How would you?
Well, I'll try to paint a picture here. Pre-COVID, let's say someone walks in and they talk with the customer service representative about what they need, and they're referred to the claim specialist that worked on the case. And at that point, they're going to get immediate service as far as getting an idea of whether it's going to be approved or not. On the downside with that immediacy, though, is there is not a control for this workload in place, meaning that at the point the customer brings us the proofs we need, the documentation, an estimate of how much money they need, receipts, that sort of thing. There's not a centralized control, so it's really all in the control of that claim specialist. So how quickly that workload gets worked is going to be left up to that claim specialist. So that's a little bit of could be a really big positive. It could be a downside depending on how the claim specialist prioritizes that workload. One positive thing about the current COVID situation, even though we are having to do everything by mail, we do have a control in place. We have everything that is being mailed in or faxed goes into a program we call WorkTrack, and for the most part, it's really all management that is scanning. For the most part, it's management scanning the documents in, or at the very least, profiling it, meaning assigning it to an employee. So you do have a control with the current environment and can monitor these requests so that they can get done, timely or based on the expectations of the office. So it can be balanced with the other workloads. So there's pros and cons to both ways.
And is there a way to sort of get special attention? I mean, I was struck, I guess Tara was talking about a client of hers that was facing eviction, and I would think that would be one where, you drop everything to focus on that. But how, is there a way to jump the queue, or is it really pretty much, it's the fairness is to just do it in the order that it comes?
Well, no, I mean, things like that, I would treat that like you would any type of dire need situation, like where we have to make a determination whether we can, cut somebody a check in the office, for example, because they missed their check and they need to pay their rent. I mean, dire need situations should always jump to the forefront. Individuals that we have coded as deceased on our records and they're not deceased. I mean, those people need immediate attention so we can get them back in pay. So, I would treat things like that in the same fashion.
Nancy, I had a question for Joanne.
Sure.
So, Joanne, I hope you can hear me and you're available and you have service.
I think she can hear you, but Joanne, if you can, you'll have to unmute. So you can start doing that now. Go ahead, Kim.
So my question for Joanne is, I'm wondering, especially since given your experience as commissioner, and I want all of our attendees and our panelists to understand that as an advisory board, we're exploring all of these issues, and sometimes what we have to do is think about, okay, if say there is not going to be legislation, or up until legislation is going to happen, or whatever the possibilities are, we try to really flesh out all kinds of different ideas as much as we can. And so I'm curious, Joanne, in terms of, especially now that, given COVID and the fact that the field is at home and there's a lot, more flexibility, relatively speaking, in terms of automation, moving workloads, et cetera, do you think there would come a time where, there could be some specialization on some of these complicated workloads that not everyone has the skill for, but who could be available to assist with just these kinds of workloads to get them processed? Or is your view that operations will always say, kind of maintain what seems to be their position of, no, we need the workers and let us decide how to use them?
Yeah, well, and that's the rub, Kim. You just identified it, because I went through this when we were working special disability claims and CDRs and things like that, making those choices in tight budget times when I was commissioner. And I think there's always the possibility, particularly with the electronic nature of the system now, that and you've got the added sort of pro to that with the COVID environment. There's always the possibility of specializing workflow. The problem is determining how many workers you need, and then you're taking them off the front lines. And exactly the point you made, operations will say, we need every single claims rep, that we have. But there's definitely that possibility. But that would require quantifying how many of these requests come in every month, and then someone doing a workload assessment of what that workload involves. I could not hear who the person was that asked the question about maybe SSA wasn't the right place to be making these kinds of decisions, and trying to come at it from a more fundamental perspective. My perspective on this whole thing is even more fundamental. I have never been a fan of policies that do what I call keeping the whole school after class because someone talked. And I think so often, a concern for someone who might do the wrong thing puts Congress in the position of keeping the whole school after class. And I think any time that an administrator can use flexibility when warranted to adjust for that, and that's one of the reasons I had focused on the administrative costs. I think the work the IG has done is helpful. If there's some way to say, look, there really aren't that many cases of misapplication going on. In other words, when I say misapplication, I mean things that are good for the child and the best interest of the child. And when you read that list of items, that's really what it is. That's what they're all geared toward. And if there's a way to quantify that, the work that the IG did and the problems that they found and how that relates to the entire workload, if there are ways to quantify the amount of time it takes for these claims reps and the amount, what it does in terms of lag time for people getting a timely response, the parents getting a timely response. Because Kim, you know this, and Nancy, you know this too. SSA's, sort of catchphrase is get the right check to the right person in a timely fashion. And when you think about it, that's really what the dedicated accounts are all about, making the right decision, at the right time to make sure that the family gets the money when they need it or gets to use the money when they need to. So I think if I were the commissioner now, what I would appreciate is something from the board that says, look, we're in this unique time and COVID demands more flexibility. People are hurting more than ever. Families with disabled children may be making other sacrifices in their family and going into debt in order to provide the services and things their children need now. So they really, really need this. And the commissioner has this flexibility. And I was not aware of the directive that you mentioned, Kim, that came out in June. But if there was a way to flesh that out some, as was suggested, I think that would be a really good recommendation to make to the commissioner. And if there's a way to quantify, again, the potential, it's sort of the law of diminishing returns. We're keeping the whole school after class, whole class after school because somebody talked. And what is it costing? What is the diminishing return on this based on claims reps being taken out offline, basically, to handle these kinds of discretionary situations and not even being able to do it in a timely fashion?
Yeah. Got it. Thank you so much.
And Joanne, I love that. I'm going to steal that. It's such a good image that one person talks and everyone has to say, Mrs. Recess. And in some ways, that's almost a good last word. We just we're getting we've got about five more minutes or so, 10 minutes before we start to wrap up. So if again, now I see Jagadish is visible and unmuted, so I turn the floor to you. I assume that was.
So thank you, Nancy. I must say the session was educational in one dimension, but not necessarily in all the dimensions it needed to be educational, in the sense that it pulled at your heartstrings because of the very sad cases that were described, but it did not really feed my brain a whole lot with the kind of information I generally ask for, which is really data on how the entire adjudication of dedicated accounts is working. But having said that, while former Commissioner Joanne Barnhart was speaking, I had an idea which I wanted to kind of run by you. I haven't made up my mind about it, but this is one possibility to consider, which is currently the legislation describes the types of expenditures that are permitted, with some flexibility on extenuating circumstances or expenditure needs that may be allowed because of the discretion allowed under the law. But an alternative approach would be to specify spending that is not allowed. Like you cannot go into a casino with this money. You cannot go into a balloon to take a balloon ride. You cannot, all of those things that seemed like frivolous consumption of, consumption that we'd frown upon. Society as a whole might have a consensus about certain expenditures that these accounts should not be spent on, and then anything else that doesn't fall into these categories may be allowed under the discretion and choice by the representative payees, whoever they are. That's an alternative approach, and the way to do that, I know there are lots of government agencies that track hundreds and hundreds of items of consumption and spending. I mean, we have the entire Bureau of Labor Statistics that compiles statistics on inflation, and they sample and track, hundreds of different commodities and items that are transacted in markets to get a sense of how high inflation is in the economy. We have surveys like the Consumer Expenditure Survey that also surveys households on their spending habits, and again includes hundreds and hundreds of items. It would take someone less than a couple of days at SSA to go through these lists of possible spending to kind of earmark or classify items that should be prohibited for spending through dedicated accounts, and then leave the rest of possible spending at the discretion of parents. If they want to spend on anything that's not in the list of prohibited items, then that's fine. That would, I think, ease the burden for even administration, because then there would be an issue about monitoring, because there has to be some way of reporting whether someone is not spending on the items that are prohibited, but maybe that could be worked out. That's the one thing that's keeping me from deciding about whether this is a good idea, but maybe it could be considered a little more in a little more detail.
Can I say something there?
Absolutely.
I think that's a great idea. I think the problem is that would require a statutory change, because again, I'm riding in the car, but the way that flexibility provision is written is the commissioner can allow other things. It doesn't say the commissioner can disallow, which would therefore, I think legal counsel would probably say, doesn't allow you to come up with a list of things that you can't do, but rather a description of things that are allowable. I mean, I love your approach. I just think it would require a change in the law, which is something that's going to be extremely difficult to get.
Right. I mean, the idea here, I mean, the driving motivation for this debate is to eliminate dedicated accounts as a policy recommendation, which would also require a change in the law.
Right.
But next to that is an alternative approach to how to specify the law. If getting rid of dedicated accounts is not feasible or there's not enough support, then maybe this is a fallback option. Anyway, these are just some random thoughts that occurred in my head just now, which is why I spoke. Thank you very much.
And any last comments before we start to wrap up? Well, let me say, I think we have reached agreement on one point, and that is that the current system does not appear to be working well, that it's, and it's really been useful to have all of these perspectives. The people who are the customers of the Social Security Administration, David and Greg and Rachel, who and Joanne, the three who are currently on the front line, and Joanne when she was commissioner and is still very involved, as you see her, she's on our call today. So there may be disagreement, and Jagadish raised some about different approaches, I think, which way to go. But I think that there, as I say, there does appear to be agreement that the current system is costing the government too much money in administration, and there's not enough payoff for what it is. And I think there was I would guess a plurality and maybe even a majority, although we're not taking votes on just eliminating them, but then there were suggestions as well. There's also the issue of what can be done legislatively and what can be done across the can be done in regulatory way. And you can hear from Joanne's remarks why she was such a fantastic commissioner, because she was dedicated to what the law said, but she was creative as well. So let me really thank all of the people who are part of this roundtable. Thank you for participating today, but really thank you much more for all the work. It's such important work that you do. And Danielle, you get a special thank you, because I think, the rest of us were talking about in sort of slightly higher terms. This is your life that you were talking about, and we really appreciate so much. And I think I speak for all of us when I congratulate you on, now you've been licensed, or you're about to take the licensing exam, or I see you're muted, so you can't respond. But in any case, we applaud you and wish you well. The good news is that this, I believe, Claire, correct me if I'm wrong, but I believe this whole session has been recorded. So if there are any who would like to either hear parts of it again or have other colleagues who might want to hear it, it will be put online. I'm not quite sure when. We have a lot of really good information that we've that I see was Emma put in the chat for all the various information that was given. And someone just actually put up a chat that I didn't see, but I really want to thank, first of all, I want to thank Kim, who is my co-moderator, and Jagdish and Bob for your excellent thoughts and questions and participation. And my really deep thanks goes to the staff who worked so hard putting this all together. So Kim, if you have any last words you'd like to say, and then I think we're on to Thanksgiving.
Yeah, I think we are. Thank you, Nancy. All well said, well put. Thank you all. We really, really appreciate it. Thank you to Emma and the staff for all of their hard work as well. And as Nancy points out, we'll get some information up online, and the discussion certainly will be continued. So thank you all very, very much. Best wishes for a safe and happy holiday season. So thank you all.
And with that, we've concluded the program. Thank you again. But to be continued. We're ending the program, but we're not ending the discussion. And we are, our primary focus is Social Security, but we also are very concerned about the SSI program. And so we are going to be doing more and calling on all of you again. We thank you again for all of your time.
Thank you, Nancy.